Please rise. The Justice of the Appellate Division Supreme Court, First Department. Greetings, equal. First Division of the Appellate Division.
Marty.
Marty. My sentence. You shall be heard.
I'm on the other side.
Good afternoon and welcome to the Appellate Division First Department. I'm about to call the calendar and I would ask that you at that time request the time that you need for oral argument. Based upon your preliminary request, we would have 7.5 hours of argument. So I'm going to ask that when you request it at this time, you request only the time that you reasonably need to accomplish your arguments. The first case is People v. Santana. Right, 8, 2, and 8. Thank you. Marcano versus 120 Hugh Grant. 5 and 1, you say? Thank you. 4? Okay. All right. 5, 1, and 4. Thank you. The matter of Justice V. Submitted. Justice V. I don't. Yeah, I don't. Yeah, it's the wrong case. Right, it's the wrong case. You don't have it. I will try to be clearer. It's hard for all of us with the masks. Right. Troy McCoy versus Mount Sinai. Submitted. American Transit versus Smiley. I'm sorry, the appellant asked for 5 and 2, 5, 2, and 5. Virouette versus Purvis Holding. 5, 2, and 4. Thank you. People versus Perry. 4, 2, and 4. Thank you. People versus Terrell Fulton. Submitted. Wilcox versus HDI Global. 5 and 2 and 4. Granted. Thank you. Natoli versus Trader Joe's East.
Good afternoon, Your Honor. Appellant request 5 and 2.
5, 2, and 5. Granted. Thank you. People versus Franqui. Submitted. Shedler and Cohn versus Aon. We have 6, 2, and 6. Aimley versus Aimley.
Yes.
What do you request?
I request a 15-minute argument.
15 minutes? Do we have a respondent?
I don't know.
Do you wish to argue since there's no respondent? You're for the appellant, correct? You represent the appellant?
Yes.
Yes. Okay. So the respondent is submitting. Do you still want oral argument?
Okay. I want to make argument.
Oh. Are you representing yourself?
Correct.
You are? Okay. And you are you're the mother?
Yes, correct.
You're the mother. You did have an attorney file a brief for you. All right, I'll give you 3 minutes argument time. 3 minutes, okay? It is enough. It is enough. If we need more, I'll let you have more, but right now, I will give you 3 minutes. Ruiz versus 829 Realty. You're both respondents? There's no appellant here today? Apparently not. Do you wish to still argue, or would you like to submit? You can do it in 2 minutes. I feel like it's Name That Tune. Okay, and Counselor, do you wish to, I'll give you both 2 minutes. Okay, thank you. Mobile Audio versus Nissan North. 5, 2, and 5. SPG Advance versus Key Bank. 5, 2, and 4 granted. Thank you. Butler versus City of New York. Submitted. Caro versus Zog Sports.
Appellate requests 5 and 2.
5, 2, and 4 granted. Thank you. Roberts versus Maxis. Do we have a respondent? Do you still want 7 minutes with no respondent? Okay, I'll give you 5 minutes. I'll hold you to that. Thank you. Okay. People versus Woodburn.
Respondent requests 3, Your Honor.
5, 1, and 3. Thank you. Lavrenyuk versus Life Care is submitted. All right, the first case on the calendar, People versus Santana. Step up, please. Whenever you're ready, you can proceed, Counselor.
Thank you, Your Honor. May it please the court. Matthew Vasilakos from the law firm Davis Polk, and I appear as pro bono counsel along with the Legal Aid Society on behalf of appellant Esteban Santana. After 4 days of deliberation and 2 notes saying they were deadlocked, the jury found Mr. Santana guilty of attempted robbery. After the trial, defense counsel learned that the jurors had searched for, found, and discussed an inflammatory YouTube video showing Mr. Santana's co-defendant, Brownie Lopez, fatally assaulting a man. This was done in violation of the trial court's clear directive banning outside research. The question before the court today is whether the Lopez video may have affected Mr. Santana's right to a fair trial.
So the court conducted a hearing over, I think it was 5 days, where the judge questioned the jurors. She questioned, I believe, all 12 jurors.
And the alternates, Your Honor.
And the alternate jurors. And based upon the hearing and based upon the statements made by those jurors, the judge stated that she was of the opinion that their viewing of the video and the viewing of the video by some and not by all in no way influenced their verdict. So based upon her credibility determinations as well as her review of the testimony, how are we to now overrule her and say that it did in fact impact the verdict?
Well, Your Honor, I think the key to this case is there are 3 jurors who testified and made statements who, in some cases, were credited by the trial court, but then the trial court didn't follow through and rely on that.
We have Marrero, Koch, and Lopez, I think, right?
And we have Juror Zhang as well, Your Honor.
Okay. And so those jurors, only Marrero, I think, was he the one who actually uncovered the video?
So Juror Zhang is the one who says that he believed he himself looked up the video, but Juror Zhang also said that at least 5 or 6 other jurors watched and discussed the video along with him. We have Marrero who said in this testimony that as many as all of the jurors could have watched the video and discussed it during the break-in trial.
But to be clear, the video in no way depicted the defendant, Mr. Santana. There was no reference to Mr. Santana in the video. He's not depicted in the video. There's no statements concerning Mr. Santana. It is purely the co-defendant, Mr. Lopez, who is depicted in the video. Is that correct?
That's right, Your Honor. But there are 2 problematic inferences that the jurors could draw from that video. The first is that bad acts inference of prior crimes. The video shows Mr. Santana's co-defendant committing a prior bad act, which makes the jurors believe that he has a propensity for violence. That same propensity can be imputed onto Mr. Santana.
Why would it be imputed to Mr. Santana?
Well, Your Honor, central to the people's case is that Mr. Santana and Mr. Lopez committed the alleged crime together. And the second key point about this video, Your Honor, is that it improperly bolsters the complainant's testimony. The similarity between the incidents in the video and the incidents here in this case are telling. The Lopez video itself shows Mr. Lopez punching and killing a man. The reporter in the video describes Mr. Lopez as sucker punching the unsuspecting victim. Tellingly, during the people's summation, the people themselves describe the current situation in the same wording. And page 347 of the people's summation, they say, quote, "It was in front of this location where the defendant and co-defendant, rather Brony Lopez, tried to sucker punch him." It is likely that the jurors gave more weight to the complainant's story after hearing the people, unwittingly of course, underscore the same language from the Lopez video. The trial court itself said in the record that it believed that this was a case that turned on the credibility of the witnesses.
So did they,
Counsel,
sorry, go ahead.
Counsel, what about the fact that the jurors all testified that it had nothing to do with their decision? They put the picture to the side, they put it down, no one focused on that.
Well, Your Honor, there's 2 problems with that. One is that the trial court credited statements from certain jurors that suggest that they were influenced by the video, but then ended up holding the other way. For example, Juror Marrero said prior to his testimony said in statements to Attorney Casey Trimble, which the court actually credited in its decision, that he had considered Lopez's past and the Lopez video in making his decision. From Casey Trimble's affirmation, Your Honor, which I could quote from, Marrero said, quote, "We heard from the victim about his life, his job, and everything. We didn't hear from your guy. Was he in school? Did he have a job? And then we heard about Brownie Lopez's past. We found a YouTube video of him punching someone." That was from Casey Trimble's affirmation, which the trial court credited in its decision. Juror Marrero went on to say, quote, "A few of us had seen it. We discussed the video, and when we saw the arrest photo, we knew it was the same guy." When he was asked whether the video influenced his verdict, Juror Marrero replied, "It certainly didn't help." So, Your Honor, we have statements here from a juror in an unguarded moment when he explained that the video was considered, at least for himself, in deciding on the verdict. And we have statements from 2 other jurors in their testimony, which the court credited, but also found parts of their statements uncredible. For example, Juror Lopez, not to be confused with Mr. Lopez himself, Juror Lopez claimed that she had not seen the video, had not heard of the video, and did not watch the video. But 3 other jurors testified during the post-trial hearing that Juror Lopez was key and central to discussions in the video during the break-in trial.
But I think
May I?
Sorry.
I just want to go on a different tack. It seems undisputed in the record that at one point, the jurors recognized that they could only consider the evidence that was produced at trial, and they decided that the remedy for any problem with this video was they would take a picture that actually was in evidence of Mr. Lopez, and they turned it over. They weren't going to consider it. What impact, if any, does that have on your claim that your client's substantial right was affected by what went on with the Lopez video?
Well, Your Honor, it's key to Mr. Santana's right to a fair trial here. Central to the allegations here was that the complainant identified Mr. Santana and Mr. Lopez as the ones who committed the alleged robbery. By turning over the photo of Mr. Lopez in the deliberation room, jurors disregarded a huge part of the defense's case, which was the identification of Mr. Lopez alongside Mr. Santana. There were problems in the record that show that the complainant did not correctly identify Mr. Lopez based on the clothing he was wearing in his arrest photo, based on his height, and all those problems are put aside when the jurors, after deadlocking twice, decided to put aside Mr. Lopez's photo. And based on testimony of the jurors, Your Honor, in this case, it seems like the decision to put aside that photo was after Mr. Lopez's past came up during juror deliberations. So in a sense, the jury, in good intentions but bad effect, put aside the photo of Mr. Lopez to only consider Mr. Santana, and in doing so, prejudiced Mr. Santana's right to a trial because they put away improperly evidence that would have exonerated Mr. Santana. And Your Honor, to turn to the last point here, the trial court erred by relying on the jurors' statements to cleanse their misconduct. We have a problematic situation where the trial court, in essence, has statements and testimony from jurors where they weren't incredible, but then gets by that by saying that jurors said that they were able to put aside the biased evidence. This is problematic for two reasons, and I see I'm out of time, Your Honors, if I may cover this on rebuttal.
Thank you.
Thank you.
You may proceed.
Good afternoon, and may it please the court. John Commendoria for the office of the Honorable Darcel D. Clark. Your Honors, the only question before this court is whether the trial court abused its discretion in denying the motion after a full hearing where 14 jurors testified, all of which said this video did not affect their decision.
Well, I think one did say, it didn't help, something like that.
I'm sorry, what did you say?
Did not one juror say it didn't help?
That was to the defense counsel before the hearing. At the hearing himself, he was trying to say that the defense counsel did not get the gist of what he was saying properly, and that he actually said they found media. Regardless, this discussion about the video and the finding of the video was before jury deliberations. It never occurred during deliberations. They never discussed the video during deliberations.
But it did affect their actions in the jury room, and they acted in a way that was inconsistent with the jury instructions. They took a valuable, or I won't characterize its weight, but they took a piece of evidence that was in the trial, the picture of Mr. Lopez, and they turned it over and said, we won't consider it. So isn't that an effect as a consequence of the video?
Your Honor, the hearing testimony is clear. The reason they turned over the photo was because Brownie Lopez wasn't on trial. Every juror that attested to turning over the photo was because he wasn't on trial, not because of the video. And in fact, multiple jurors during the course of the hearing did say they did deliberate over the photo, if not for seconds. But the reason why they didn't pay much weight to it was because he was not on trial.
But the photograph had been introduced into evidence, had it not?
It was introduced into evidence.
And the defense position was that there was a misidentification, or at least there was some type of mix-up in terms of whether it was Lopez who did certain thing and Santana who did something in terms of their actions.
Correct. That was the defense's theory, but it's the jury's purview to accept or deny any of the theories presented by the parties or the evidence presented. They don't have to accept everything in total.
But as my colleague just stated, apparently the reason that they disregarded that photograph, which was in evidence, was because it created too many issues based upon the video.
But the record doesn't...
That's what they said. That's what the jurors stated. They stated that in order to block out the video and make sure they weren't considering the video, that's why they turned over the photograph of Mr. Lopez.
Your Honor, if I may, one of the jurors during the hearing, one of the ones that actually had seen the video prior to deliberations, this is Marrero, who did not watch it during deliberations or during the trial at all, quoted, "It had nothing to do with this decision that we were about to make. It wasn't important to anyone. It had nothing to do with the case, Had nothing to do with the facts and evidence that we were reviewing, and no one brought it up.
Well, did they have to review the photo regardless of whether they decided to give it no weight? It wasn't evidence. They had to look at the photo and say, if only to come to the conclusion that this is not necessary for us to make a decision.
And they did, in fact, do that, even if just for seconds. They did look at it, they said, that's co-defendant, and then they turned towards defendant.
So
And
in
there's
your
no
opinion, seconds doesn't matter? 1 second, 2 seconds, 15 seconds, they're all the same? Isn't 1 second too much for that kind of consideration?
In light of the fact that the defendant generally matched the victim's description almost perfectly, to the red jacket, the red hat, the pimples, the voice, the admission of guilt, come on, Mexico, we were only playing, we weren't going to hurt you. In the face of that evidence, to question whether the co-defendant, whether the co-defendant was guilty or not has nothing to do with whether the defendant was guilty.
But doesn't the Newlander case hold that it doesn't matter about what proof there is of guilt? The defendant is entitled to a fair trial, right? And a fair trial will ensure that the jurors are paying attention to the judge's instructions and not doing outside research.
Correct. And that is what came out during the hearing was
But
that.
counsel, I'm also not understanding because the complainant was unable to identify the defendant. At the scene, he was unable to identify the defendant, and in court, he was also unable to identify the defendant.
At the scene, he was able to identify the defendant once he stepped out of the police vehicle.
I thought he said, I'm not sure.
He said he was not sure at first when he was in the police vehicle with the window up over 15 feet away. Once he got a little bit further than where he was during the crime, he was able to identify them with 100% accuracy.
But he didn't identify him at trial.
No, he did not.
Right, so this is, I guess what I think we're getting at is that this was not a case where the evidence was irrefutable. There actually was, it seemed to me, at least to me, particularly in light of the fact that the jury couldn't reach a verdict and needed Allen charges, that it was a close call. Does that make a difference here?
Not in this instance, not after the full record of the hearing supports the court's decision. This is a collateral issue at best regarding Brownie Lopez's video. That video was, again, as your honors have pointed out, not a defendant. It had nothing to do with the facts of this crime. While he was alleged to have punched the victim in the video, there is a stark difference between a person approaching someone outside of a bodega with a shirt off and harassing that person as opposed to punching a victim who is not...
Well, the report was that the punch led to the man's murder. I mean, it was not an insignificant video. It was part and parcel of news reports.
That is true, and...
Yeah.
And it's also interesting that your adversary said that during summations, the assistant district attorney referred to a sucker punch. And then in the video, you have commentary about the actions of Mr. Lopez as a sucker punch. So I recognize that most probably the assistant district attorney, did not, do it intentionally. But is there prejudice to the defendant based upon that? That you have the assistant district attorney in summations talking about a sucker punch during this attempted robbery, and then you have a video showing the co-defendant sucker punching this individual in front of bodega, and then the individual ultimately dies?
No, Your Honor. And to the extent my colleague relies on the statements from the video, that was first raised for the first time in reply. And with regards to the video evidence submitted during the hearing, it was a 12-second clip that Daniel Marrero reviewed without sound. And I see that I'm out of time, and we do ask for an affirmance.
Thank you.
Thank you, Your Honors. I'd like to address the people's point that this was a collateral issue. In People v. Brown, we have a situation where a juror conducted a visibility test to see if the way the sole witness linking the defendant to the robbery could have actually identified the defendant.
Yes, but
Now,
in this case, the video wasn't of the defendant, it was of someone else.
that's correct, Your Honor. But in People v. Brown, in finding that this test violated the defendant's rights, the Court of Appeals noted that the eyewitness credibility was not only at issue, but was crucial to the prosecution's case against the defendant. Here, the complainant's eyewitness testimony was the only witness who identified Mr. Santana and Mr. Lopez having committed the crime against him, allegedly committed the crime. Here, again, we have that key, the complainant's testimony was at issue, was crucial to the prosecution's
But
case.
here we also have a full-blown hearing where the jurors are questioned, where the jurors state categorically that they did not consider the video in coming to their verdict. We also have a jury charge that the court made to the jury prior to their deliberating. So how do we go beyond that? Why would we not accept the statements by the jurors that the video of Mr. Lopez in no way affected their verdict of guilty as to Mr. Santana?
Well, Your Honor, that goes to the last point I wanted to raise to this court. In relying on the jurors' statements to cleanse their misconduct, the trial court creates a problematic standard. First, it ignores that jurors, and frankly all people, are inherently bad at determining what influences their decision-making. Research has shown that people are consistently swayed by prejudicial information, even when they explicitly deny having considered that prejudicial information
I
themselves.
thought that she actually gave a nod to the idea that they could be persuaded by it, but then found, according to the standard, which is affecting a substantial right, or whatever the exact words are in the statute, that it still didn't rise to that. Why shouldn't we defer to her judgment on her discretion on that? I'll let you answer that question.
Thank you, Your Honor. The reason the trial court got this wrong is because it credited statements from juror Marrero and other jurors that disputed their ultimate conclusion that they were not affected by prejudicial information, but then discarded that when making its decision. We have statements from juror Marrero that says he considered that information. We have testimony from juror Lopez where she attempted to hide the fact that she watched the video. We have statements from juror Zhang who said that he watched the video with 5 or 6 other jurors. All of that taken together, Your Honor, suggests that Mr. Santana's right to a fair trial was prejudiced. Thank you.
Thank you. I understand from your appearance that you're appearing here pro bono, so we thank you for your pro bono service. And please thank your law firm as well. And we thank both counselors for their argument on this interesting case.
Thank you, Your Honors.
Marcano versus 100-120 Hugh Grant.
Good afternoon, Your Honors. Greg Friedman for the plaintiff appellant in this case. Now, defendant's argument, the entire argument comes down to plaintiff lied about this entire accident, and it's totally impossible for there to have been snow or ice at the location where he fell. It's a tough argument on summary judgment because almost invariably it's a jury that gets to decide credibility issues. And I think the trial court ignored that here and essentially gave defendant the benefit of favorable inferences.
Didn't the defendants here submit an expert affidavit, a meteorologist's affidavit that said there was no snow or ice and that the temperature was too high for a certain period of days to allow for any accumulation of ice or snow, was way above freezing?
Right, what defendant's meteorologist said was based on the weather records, there wouldn't have been any natural accumulations of snow or ice. I believe it was in the 3 days before the accident.
85 hours, I think.
85, right, about 3.5 days
Right.
before the accident. But plaintiff described what he fell on as a fairly thick layer of hard snow and ice. So I think when you pair this with their store manager's testimony that he had no idea what snow removal had actually been undertaken in the time leading up to the accident, is what plaintiff testified to really so impossible especially when you should be giving him the benefit of all favorable
Let
inferences.
me ask you a question, though, because we have lots of cases like this, and I think we have a fairly developed bit of case law that says that when a defendant comes with an expert meteorologist who describes the conditions, the weather conditions, in the days preceding the accident to rule out the accumulation of snow and ice, that will support a prima facie case, correct?
There is a body of case law saying
Right.
that, yes.
So were you required to at least get an expert to explain to the court how, based upon the weather conditions of when the last snow event and the temperatures that followed would have resulted in some such accumulation?
I don't believe so in this case, and here's my reason why. If you look at the weather records, the preceding month was terrible. I believe it averaged approximately 30 inches of snowfall when you look at all the surrounding areas. And I understand defendant's argument that it warmed up after that, at least for certain days, and there wouldn't have been any residual snow left on the ground had defendants completely ignored it, left it as it was. But we know there's an allegation that they negligently performed
So
snow
why didn't
removal.
you come forth with an expert or someone to say exactly that, to refute that?
Why? I don't know why, but I also would say it's not fatal in this case because I think especially given defendants' complete inability to say what they did with these near 30 inches of snow in the time leading up to the accident, it was their burden to show that they didn't either create or exacerbate whatever would have been left over there in the time leading up to the accident. Would our own expert have helped?
So you don't think they made their prima facie case out?
I think given the facts of this case and how much snowfall there was before, they had to come forward with some kind of evidence, not only of what snow would or wouldn't have been there had the area been left untreated, but what was actually done to
But it was
clear
not
the snow
only
that had fallen.
untreated, but it was also the temperature, because at some point, I think the temperature rose to the mid-60s.
The temperature was quite warm, according to records, on the actual accident date.
And then the average apparently was 48 to 52 during that period of time. And your client testified that there was about 3 to 6 inches of hard snow on the ground. So how do you get 3 to 6 inches of hard snow on the ground when the last snowfall was, I think, according to the reports, was 19 days before, and you have temperatures in the mid-60s?
I think there's still at least a permissible inference that given the amount of snow leading up to that date, had defendants actually removed snow, which the manager obviously gave his general practices, he didn't say we would have left it untreated, it was still on them to explain, at least in some fashion, what they did with all of that snow, and that's our position. If there are no other questions, I think we'll rest on the brief.
Thank you.
Thank you.
May it please the court, Eileen Baumgartner with O'Connor, Hintz, and Devaney for the defendant's respondents. It's our position that the decision here of the lower court was properly decided. This case involves one of those rare situations where the plaintiff's testimony is so incredible that it is appropriate for the court.
Counsel, if you could address plaintiff's argument that the lack of expert affidavit is not fatal to their position in this case?
I think it's absolutely fatal here, and that was the court's decision that they were supposed to come forward with a meteorologist, and that is the correct decision. In fact, if you look at the opposition to the motion, there really was no discussion of the meteorologist's findings and what he stated in his affidavit. Instead, they simply argued that there was a non-delegable duty to remove the snow and ice, that the defendant failed to attach records demonstrating that they had removed it, and that his testimony raised an issue of fact, even though it was clearly refuted by the weather records that were submitted and attached to Mr. Roberts' affidavit. we submit that in this case, we weren't required to show that there was a lack of notice, because in fact, we showed that there was a lack of a condition. The affidavit, as we've talked about, the last measurable winter event occurred March 3rd. This is a March 22nd accident. That's 19 days beforehand. Plaintiff talks about, in their appeal, about the fact that there's 10 inches of snow on February 19th, but if you look at the weather records, the next day there's 7 inches, the following day there's 5, then there's 1, and then there's 0 as of February 24th, almost a full month before this accident happens.
Well, were you, as part of your prima facie case, required to show that the snow that existed 19 days before had been cleaned up?
I don't think that that was necessary for us to show, no, because as I said, we had this affidavit from the expert who establishes that there is no snow in exposed, untreated areas, which is essentially what plaintiff testifies to when he's asked about the condition. He's asked, just before you fell, did the area where this accident occurred had been cleared away at all? And he says no, because the snow was still there. That was 95 to 96. How big was this hard snow that you apparently fell over? It was the entire sidewalk. Did you see any piles of snow on the edges of the sidewalk? No. So he's essentially testified that this is an area where nothing has been done to treat it, and that is impossible based on the weather records that we submitted.
Well, should you have to refute that by saying that something was done to treat it, other than your witnesses' statements as to what the common practice was? Because you had no records or anything, is that correct, in terms of what was done to treat the area?
We did not have records, but given the length of time that had elapsed and the fact that there was no precipitation in that period of time, including in the time where plaintiff claims snow fell 6 inches, and the fact that given the temperatures, anything that had been present would have melted and was not, and would have been 0 at the time of this incident.
Thank you.
Thank you.
Rebuttal?
I think we covered the main points earlier, so I should be very brief here. Yes, there are some instances when a court will consider testimony to be incredible as a matter of law. I get that, but how often does that happen? Especially when, like here, you've had a series of snowstorms, including up to 30 inches, and a defendant who has absolutely no idea what it did in response to them or keep any records. I think at the end of the day, there's a credibility issue here that you simply cannot get around. And for that reason, I think that summary judgment should have been denied to defendants here.
Okay.
No other questions? I rest again.
Thank you.
Your Honor.
Thank you both. Right, the next case for argument is American Transit versus Smiley.
Good afternoon. May it please the court. Albert Gallatin of the Scahill Law Group. It's our position that the lower court should have granted the motion to dismiss. We represent Ms. Johanna Smiley. The letters that were sent regarding the subrogation and the PIP payments letters were sent to State Farm only. They were not sent to the Smileys. The lower court...
Did they have to be? Wasn't there an insurer, an agent for purposes of notification in this circumstance on the subrogation?
We would submit no, and even the
Why
court,
not?
lower court says so. The lower court in its decision says that they had to be notified, that the defendant and State Farm were notified. But the letters, the lower court got the law right, that the defendant and the defendant State Farm needed to be notified, but that's not what happened. They were not notified, Mrs. Smiley.
I'm sorry, I didn't understand. Why would it not be sufficient to notify the agent who is acting under the scope, within the scope of the agency?
State Farm is enacting, we submit that the law is that you have to notify the person. This isn't American Transit versus State Farm. You have to put the person on, you have to put the actual person on notification. It's also our position that the letters themselves aren't the subject of this action. This is a subrogation action based on payments made to David Ortiz.
So I thought in Center v. Hampton affiliates, I thought that that case stood for the proposition that the agent, it was sufficient to notify the agent.
I can't hear you.
I'm sorry, in Center versus Hampton affiliates, I thought it was that the agent acting within the scope of the agency, that it was sufficient to notify the agent.
It's not, it's our position that there's no agency here. State Farm is not, State Farm is acting as the insurer. They're not an agent for service on Smiley. You're notifying, this is a claim against Smiley, not a claim against State Farm. And even if you were to say that State Farm is a correct person, the letters themselves are incorrect. American Transit is doing a subrogation action against Ortiz. The letters themselves, which are in the record on page 49 and 51, notify us of a subrogation claim against Ronald Morales. That's not the subject of American Transit's action. American Transit, in their summons and complaints, say we're subrogating based on Mr. Ortiz. The letters put us on notice of Ronald Morales. As such, the letters themselves don't put us on notice of the proper subrogate.
But there were subsequent subrogation notifications that dealt with payments that were made by the plaintiff on behalf of Ortiz, weren't
There were. Some of them are.
So they knew that medical bills under no fault were being paid on behalf of Ortiz.
That's after the release. There's one letter, the 912 and the 917 release. There's some question of fact. For that, we would agree that we should not get the motion to dismiss on that letter. There's a question of fact. But on the two letters prior to that, that being the July 19th and the August 17th, those are for the wrong person. So even if the letters to State Farm are good, they didn't put us on notice of Ortiz for those two letters. If there are no other questions, I'll waive the rest of my time. Thank you.
Good afternoon, Your Honors. Please the court, Dennis Murphy on behalf of the Stutman Law Group for the plaintiff respondent.
So were those payments made after? Is your adversary correct in terms of?
No, Your Honor. The release is dated September 10th. The first notice of medical payments related to this accident was sent to State Farm in July. However, they're correct, that first notice does not reference Mr. Ortiz specifically. However, on September 7th, prior to the execution of the release, a subsequent notice was sent to State Farm, specifically referencing that payments were being made on behalf of Mr. Ortiz. So they had that before the release was executed or received or payment made.
So then the question comes down to, or one of the important questions, is whether by notifying State Farm, that constituted notice to Mr. Smiley as well.
Yeah, yes, Your Honor, and I believe this is a principal agent situation where notice to State Farm would act as notice to Mr. Smiley. At the end of the day, State Farm was the one administering the claim. They arranged for the defense, they paid for the defense, they negotiated the settlement, and I'm talking about the underlying personal injury claim where Mr. Ortiz signed a release. And they paid that settlement out. State Farm was the party.
Does that make them an agent? I mean, that happens in almost any accident case in which insurance is involved.
Correct, Your Honor, and they're the party.
And it doesn't mean that Mr. Smiley and the insurance company are one and the same.
I'm not saying they're one and the same. I'm saying in this for purposes of administering the claim, they're acting as their agent. They're handling all aspects of the claim. They're the party that needs to know.
Is there anything that you base the agency on other than their actions? Is there a document or something that they signed or that's in the insurance policy that would otherwise establish this agency relationship?
Well, Your Honor, first of all, it has to be noted, these are all arguments that were not made in the underlying motion. These are under arguments that would be made for the first time on appeal and are also made in a subsequent a motion to re-argue.
So if there were documents, you wouldn't have known to put them in because it wasn't argued.
Correct, Your Honor. And again, at the end of the day, the party that needed to know about these payments was State Farm because they're the ones that are ultimately going to make payments under the policy. If Mr. Smiley received those notices, we don't know, would he have sent them to State? What was he going to do with them? Would he send them? He would send them to State Farm, presumably, if anything, for State Farm to handle.
But I guess what I'm having trouble with, and I guess it's always the problem in these cases, is that the insured and the insurance company are not necessarily the same. You know, their relationship is contractual.
Correct.
Right, and so, like, let's, for instance, you know, if an attorney is hired to represent Mr. Smiley by the insurance or the insurance company pays, it's still Mr. Smiley's attorney. It's not the insurance company's attorney, right?
And just the same, a notice to the attorney would be impugned upon Mr. Smiley.
But you didn't notify the attorney.
We notified his insurance carrier.
But if you
which should also
notified
be
his
impugned.
attorney, it would be a whole different thing, wouldn't it?
I don't believe there's any difference in this scenario. State Farm was the party.
And I
that needed
keep
to know.
asking you why? Why?
Why are they the one that need to know? Because they're the ones. If
No,
they
no,
make the
why are
payment-
they the agent? What makes them the agent?
Because
Is
they
it
had an agreement to
contractual?
hand.
What is it that established the agency?
Well, they do have an insurance policy where
Well,
Mr.
but that
Smiley hires them to handle the claim.
Is that what?
And that's what an insurance policy would be for, to handle the claim and pay
That's not
out.
exactly what an insurance policy is for, but I grant you, it could be in the insurance policy, but we don't have that, do we? Okay, thank you.
Thank you.
All right, rebuttal?
It's more factual. There were 3 letters before the release was signed, and it's 49 and 51 and 53. The first 2 letters do not reference Mr. Ortiz. They're totally on Mr. Morales.
What about the July 7th letter?
The July 7th letter it's a July 19th letter, and that's only Mr. Morales. The August 17th is only Mr. Morales, and the 9/7 letter is both.
There is no 7/7 letter that your adversary referred to?
7/17, 7/19.
9/7. There was a 9/7 that State Farm had paid for Morales.
Yeah, the 9/7 one, and if you're,
And also that it had covered $19,000 of Ortiz's
yes,
medical bills.
that's the letter that I'm willing to admit that if you don't grant me on the first relief, that would be, I can't win on that. That's a question of fact on the
The 9/7.
9/17 letter.
Yeah.
But the other ones should have been dismissed, the other 2 letters. Thank you.
Okay.
Viruet versus Purvis, step up, please. You can proceed. Thank you.
Good afternoon. May it please the court, Vincent Chirico for plaintiff appellant. In this labor law 240 and 241 case, it is not disputed that overhead activity was clearly taking place, including deconstruction and dismantling of concrete forms, including the one that fell on the plaintiff. It is not undisputed that plaintiff was told to go and clean debris underneath those forms because an inspector was coming and that debris was a safety risk. And it's undisputed that the concrete form fell on the plaintiff. Under those facts, we believe that the trial court erred on two grounds. First, to decide that there were triable issues of fact as to what caused the form to fall, and two, as to what, if any, safety devices would have prevented the incident. Now, on the first issue, it is settled First Department law that the lack of certainty as to what causes an object to fall does not create a material issue of fact. That's the Vergara case that's cited in our brief, and it's a principle that has been reiterated just this past June in the Sanchez versus One Burgess Plaza LLC case, in which Justice Shulman presided. The one case that both sides agree on that applies is the Fabrizi case. We believe that the Fabrizi case is appropriate in setting the applicable standard, but we believe that it's distinguishable in the result. In the Fabrizi case, the plaintiff argued that there should have been a better screw coupling to secure the conduit that fell on the plaintiff. In this case, plaintiff is not making an argument as to whether anything was a safety device, but rather the argument is that no safety device whatsoever was provided to secure the form from falling. So regardless of the precise manner in which the incident occurred, it's at least partially attributable to the failure to protect plaintiff from an unsecured concrete form. And that is the Noble case that we cite in our brief, in which Justice Mazzarelli, you were presiding. So the defense speculates heavily as to whether some pins that were securing the concrete form in place were, quote unquote, a safety device. We believe that is totally irrelevant. Unlike in Fabrizi, plaintiff did not undertake any work on the form and doesn't rely on any speculation as to whether pins were a safety device
Well,
or
there's
not.
actually no proof in the record, one way or the other, about whether there were pins.
Correct.
I mean, the most I saw was that your client during deposition thought maybe the pins malfunctioned or that they weren't secure, but he didn't know. He didn't see pins.
Pure speculation on the plaintiff's part. It could have been that. It could have been something.
And no defendant came forward and said there were pins,
Correct, Your
right?
Honor.
So we don't know.
Correct, Your Honor. And the second error on the 240 is to find triable issues of fact as to whether any safety devices would have prevented the incident. Again, we believe that the trial court assigned plaintiff the burden of proving which of the enumerated safety devices was necessary, but expert evidence is not required to prevail in a 240
Okay,
case.
Counselor, can you talk about the accident that occurred on January 8th? Because you're just talking about the January 6th incident.
Certainly, Your Honor. On page,
And let me just to sort of set this up a little bit, they were two separate accidents, right?
there were, this January 6th.
And you're claiming you're making two separate claims here based on those two separate accidents that have different elements of damage.
Correct, Your Honor. On the January 6th accident, we're claiming both a 240 and a 241 claim. And on the January 8th accident, we're claiming two different 241-6 claims. And I just want to direct to the court to pages 445 and 446 in the record, in which a picture paints a thousand words here. Page 445 depicts the grinder that was given to plaintiff on the day of the accident, and page 446 describes the way the grinder should have appeared and should have been protected. Now,
That grinder had no blades, safety guard, or side handles, right?
correct, and on all those defects, plaintiff specifically told his supervisor, hey, you have the wrong guard on here. You got to do the job anyway or go home. We don't have a side handle. You have to do the job, just cut it with what you've got. We need a cutoff box for the extension cord. We don't have one. Go with what you got or go home. I see that my time is
The
up.
cutoff box isn't actually part of the grinder, though.
No, it's part of the extension cord, Your Honor. I see
Okay,
my time is up.
Yes, you'll have some time on rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the Court, Anthony DiStefano for the defendant's respondents. Addressing the Labor Law 240 claim, it is undisputed at this point that the forms were being removed at the time of the accident. The very goal was to remove the forms. Now, plaintiff was not engaged in that work. Plaintiff was cleaning debris on the roof. However, he testified at multiple points during his deposition that the forms were in the process of being removed, and that the way this form came down was because the pin had been removed. And he does use the word probably.
But he didn't see the pin. When he was pressed on that, he said, I didn't really see pins. I'm speculating, right? There's no testimony from anybody who said, I saw pins.
Correct, Your Honor. What he testifies to at page 171 of the record is the only way that thing will come off if someone removed the pins. That's what he testifies to. So that's what happens here. The pins are removed and the
Yeah, but
form...
again, but he doesn't even know that pins were holding it up anyway. I mean, he says it, but isn't that just rank speculation?
Whether it's rank speculation or not, Your Honor, the point is that the pin had to have been removed for the form to have
Why?
hit the wall, correct? Because the pins were what was holding
How do
the
we
form
know?
together.
How do we know that?
Because he testifies that that's the way the forms are held
He
together.
didn't have any knowledge of that, though. That's what I'm trying to get to.
Even if
I don't get it. There's no evidence in the record that pins were otherwise holding up this form.
Even if we put aside whether or not there were pins holding up the form, it is
Okay.
undisputed at this point that the goal of the work was to remove the forms, correct? So, not correct. I was
I
not
don't know
asking
if
Your
it's
Honor a
correct.
question.
I know that's your, right,
Right.
I
I
understand.
understand.
That's what you'd like us to conclude.
Yes, Your Honor.
Okay, I know.
I apologize.
You're not asking us to conclude that that was what Mr. Verrett was sent to do. He wasn't there to remove the forms.
Yes, Your Honor. He was not there to remove them.
No, so he had no role in that, correct?
Yes, Your Honor. So what I'm saying is that if the goal of the work of his coworkers is to remove the forms, then the question is what was needed to control the descent of those forms, and that's
Why
the
was he
Lewinsky
sent
case out of
there?
the Court of Appeals.
What was he sent there for?
He was sent there to clean the roof, to make a path for the inspectors,
To make a path for inspectors.
for inspectors to come in.
Correct.
So they would get hit by the forms. Right?
No.
Sorry, I take that back.
So they wouldn't trip over debris,
Correct. So that has nothing
which
to do with...
shouldn't have been there pursuant to the labor law regulations, the industrial code regulations.
The debris, Your Honor?
Right.
The debris should not have been there, so,
Right.
but that's not an
Aren't there
allegation.
industrial code regulations which make reference to cleaning up the work area?
There is no industrial code provision that the plaintiff relies on here that has anything to do with
I
cleaning.
know that, but he's sent there to make sure that the area is clean, correct?
Yes, Your Honor. He was sent there to make sure the area was clean. I could move on to the Labor Law 241 sub 6 claim. With regard to the guard, the trial court found that there was a question of fact as to whether or not the removal of the guard was a proximate cause of the injury to the plaintiff. In other words, if
But I understand that argument, but how do you address the argument made by your adversary in the brief that there were defects in this grinder, and which aren't disputed, and that had the defendant been acting in accordance with the industrial code, that grinder would have been removed from service before anybody put any blade in it? Doesn't that make the defects in the grinder and the violation of the industrial code at least a proximate cause of the accident?
Except for the accident could have happened even with a guard on a grinder. Even if a smaller blade had been used and there was a guard on the grinder, the accident still could have happened, is what the trial court said.
But how does that cut in your favor? It should have been removed from service, right?
But even if he was using the grinder that is in the record with the guard on it, what the trial court found was the accident still could have happened. In other words, the position of the plaintiff's hand in relation to the grinder could have been such that when the grinder came back on, it would have hit his hand anyway, regardless of whether or not there was a
But if
safety
it
guard
wasn't
on
in service, he wouldn't have used that grinder, right?
That is
right? Okay.
Thank you, Your Honor.
Thank you. Thank you. All right. Rebuttal?
Thank you, Your Honor. Industrial Code Section 23(1.5)(c)(3). All safety devices, safeguards, and equipment in use shall be kept sound and operable and shall be immediately repaired or immediately removed from the job site if damaged. Industrial Code Section 23-9.2a obligates the immediate repair or replacement of defective, unsafe equipment upon discovery. Our contention.
Isn't it your claim that the way this happened was that the switch, that the machine went off and then went back on again on its own?
Correct, Your Honor. And it was the lack of the safety guard that caused plaintiff to hold it in a different manner so that when it turned back on, the lack of the safety guard and the lack of the proper cutoff switch in the extension cord caused this blade to cut his finger. And those are the two defects.
Well, the cutoff switch is a different piece of equipment, though, right?
It's connected. You can't power a grinder without a
Without
power
electricity, we know that.
cord. Right.
Yeah, but that doesn't make it, that, the defects that pre-existed in the grinder were something different. It wasn't the power cord. The power cord wasn't part of it.
Well, certainly, I mean, our contention is that it was, but even if it's not, you still have two other defects with the grinder that we believe were proximate causes of that accident that were both violations of these two industrial code sections. And as to the 241 claim on the January 6th accident, again, 23-1.7A1 holds that every place where persons are required to work or pass that is normally exposed to falling material shall be provided with suitable overhead protection. The trial court below held that it's not clear that the use of the protective structure described in the section would have been feasible. And in so doing, we believe that the court assigned the burden to plaintiff of proving which safety devices were necessary. But it's undisputed that at the time of the accident, work was regularly ongoing overhead, including specifically the removal of these concrete forms, and that thus that was a foreseeable risk of regularly falling objects.
Thank you. Thank you both.
Thank you.
People versus Perry. You may proceed.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent Appellant Dwight Perry. May it please the court. The court here failed to ensure that Mr. Perry had adequate knowledge of the risks of representing himself before allowing him to proceed pro se. A searching inquiry has two parts. First, the court must establish that the defendant is aware of the charges against him and the possible consequences should he be convicted. And second, the court has to generally inquire if the defendant understands the risks of self-representation and what they're giving up by foregoing representation by an attorney. Here, the court failed in both respects. In People v. Jackson and People v. Rodriguez, this court held that a defendant must be made aware of the specific sentencing exposure he faces before he can be allowed to proceed pro se. Here, the court never asked Mr. Perry whether he understood the sentencing consequences about this case or about this case in combination with the other charges that were currently pending before the court. The court also failed to ask Mr. Perry whether he understood the nature of the charges against him. In the searching inquiry, the subject of the charges for which he was on trial never even came up. He was charged with criminal possession of a weapon in the third degree. The court never asked whether he understood what those charges entailed, what the elements of the crime were, and what he understood he was undertaking.
Yeah, in fact, in a prior court appearance, the defendant expressed some confusion about his understanding of the charges. Does that affect the nature of the kind of allocution or searching inquiry that the court should have had in this case?
Well, it surely does. I think Your Honor is referring to a September 22nd appearance before Judge Zweibel, who ultimately took the waiver of counsel. And my client expressed that he was just beginning to come to grips with the charges. And yes, the court should look at the record as a whole to determine, whether there was a knowing waiver, and if the defendant has expressed a lack of understanding, then that heightens the obligation of the court. So the court.
Counsel, there's no specific colloquy in terms of what a court has to go into in terms of self-representation, is there?
That's correct, Justice Weber. There's no mandatory catechism, but there does have to be a meaningful inquiry. And that meaningful inquiry is those two parts. There has to be an inquiry about the specific charges and the possible consequences, including sentencing exposure. And there has to be an inquiry into the general risks of proceeding pro se. So here the court, on the latter part, did ask about whether my client had an understanding of the rules of evidence, and my client assured the court that he did. But if you look at the model pro se colloquy, it calls for much more than just asking about whether the defendant understands the rules of evidence. There are lots of strategic reasons why you should not forego counsel. If you're giving a summation and you're pro se, the jury may be unlikely to believe you because you're suspect. Whereas,
just a housekeeping matter, are you challenging the judgment on the indictment 2830 of 15, where the defendant was convicted of attempted robbery in the third degree?
We are not challenging that.
You're not? Okay, thank you.
Thank you, Your Honors.
Thank you. You may proceed.
May it please the court, my name is Ellen Friedman, representing the people. Your Honor, in this case, the court provided the defendant with detailed warnings about the pitfalls of representing himself and the benefits of being represented by counsel. There are a number of proceedings, and starting from the beginning, Justice Burke warned him after he first said he wanted to go pro se that he'd be.
Let me ask you a question. I mean, will you all accept the general proposition that there's no specific words that the court has to use in conducting a searching inquiry? But are there certain elements of information that the court has to make sure that the defendant knows in order to have a good searching inquiry? And just let's use by way of example the sentencing exposure. If there's no indication that the defendant has been informed or knows about the sentencing exposure, does that make the searching inquiry defective?
Okay, Your Honor, let me first answer generally and then get to the specific part of your question.
It's a complicated question. Go ahead.
So the colloquy does not have to include a detailed discussion of every aspect of trial advocacy. The court has to be sure that the defendant understands the risks of proceeding pro se and likely lacks the knowledge to perform vital trial functions. Courts have approved of colloquies like this one that mentions several examples of functions that a defendant would have to perform on his own. And of course, you have to give more than just generalized warnings. But in this case, the justice in the colloquy expressly warned of several issues he might have and pitfalls, not knowing the rules of evidence, how to choose a jury, when to object. And there are a lot of cases that hold that giving examples like that is enough. Talking about specifically about your question about the sentencing, what he knew about sentencing. In this case, although the judge himself didn't spell out his sentencing exposure, it was clear from the record as a whole that he did understand the sentence that he faced.
But doesn't that information...
How is it clear from the record? I know you stated in your brief, your argument, that I think months before there was some mention of the possible sentencing, but there was nothing stated by the judge during the defendant's request to go pro se. There was nothing stated specifically as to his exposure.
There wasn't on that day, but on the other days, it was made clear on the record that he faced 3.5 to 7 years, and that was the maximum time that he faced. And on both of those occasions, after hearing that, he said, I want to go pro
Should
se.
that not have been reiterated to the defendant at the time that he was requesting to go pro se? I thought that perhaps we said that in People v. Rodriguez? That it
It's
had
very
to be
different from,
stated to the defendant?
I believe that it's completely different from People v. Rodriguez, because in that case, the court actually made clear that as long as the record shows that he understood it, the judge doesn't have to say it explicitly. You have to look at the record as a whole. And the difference is, in Rodriguez, and then there was another case that was similar, Jackson, was that there was a really significant gap between what defendant was told he could receive and what his actual exposure was, with the actual exposure being much higher.
But it was 7 months before, was it not, that these statements were made? Wasn't it approximately 7 months before that he was actually told about the 3.5 to 7?
It was before, but it was still part of the record about during his request to go pro se, and I believe that Rodriguez said you look at the whole record.
7 months before?
I think so, Your Honor. I think that the record as a whole showed that he understood the charges he faced, and he understood
Do you
the
remember what
sentence that he
happened
faced.
7 months ago?
I believe that in this case, the record is clear that he understood his exposure. If there are no further questions, I see my time is up, and I rest on my briefs.
Thank you. Rebuttal?
Unless the court has any questions, I'll waive my rebuttal.
Thank you very much. Thank you both. Wilcox Development against HDI Global. Step up, please. You can proceed.
Good afternoon, Your Honors. My name is Sherry Pastor, and I represent HDI Global. In this case, the issue is the duty to defend is broad, but it is not absolute. And sophisticated parties have the ability and right to contract to narrow it. In this case, the court, in analyzing the duty to defend, looked at only part of the contract and not the limitations included in it. And that was the trial court's error. It should have completed the analysis and looked at the limitations. And I think that what the court will find is that the trial court appropriately applied the case law, including Regal, but only to a point. That case law that the court relied on were all cases that had no limitations in them. And the court in Regal and those cases never said, and to the contrary implied, that where there were limitations, they would not be ignored.
Would you not agree, counsel, that that as you acknowledge that the duty to defend is very broad, that based on the pleadings and the totality of the record before the court, that there could be the possibility of coverage, particularly when the injured plaintiff worked for TKE?
In this case, there was not the possibility of coverage, Your Honor. In this case, the employee was injured and was arguing that the environment, the safety barriers, were insufficient. And in fact, Judge Rivera made very clear that the issue in this matter is the sufficiency of safety barriers, and the parties' contract put the safety barriers, either to have them there or not, firmly on Wilcox. And its people testified that their view was they didn't think they were required. So what the court will be deciding at the trial court level will be, were the barriers required or not? And
well, isn't there also in the case a question of comparative negligence by the plaintiff?
As between the plaintiff at the trial court level and whether there's allocation, that does not have issue to do with the insurance.
I didn't ask that.
Oh,
All
I'm
I
sorry.
asked is there an issue of comparative negligence in the case? And your answer implies yes, there is.
I
Right,
would,
so let's start from there, and let me ask my questions, because I'll get there, okay? So then, the plaintiff was an employee of here, insured, correct?
that is correct, Your Honor.
And don't we have case law that says that when in the pleadings, there is an issue of comparative negligence that involves the employee of the insured, that for purposes of deciding coverage, that we look at those pleadings and we would say that we can't determine now that only Wilcox is responsible. It may otherwise arise out of what the plaintiff did as well, and boom, you get at least indemnification for defense costs. Haven't
No,
we said that?
Your Honor, I would disagree in terms of this. The plaintiff in this case is not suing, saying that if he did something wrong, he wasn't suing himself or acknowledging that if he did something wrong.
You never sue yourself.
I understand, Your Honor.
Okay, so.
No, but
right.
my point is,
But we do have case law that says that, right?
you have case law that would say that if there was a plaintiff who were negligent, what would have happened? What will happen here is either Wilcox was supposed to put in the barriers or they didn't. If they were supposed to put them in, that falls on them. If they weren't, that doesn't mean that the plaintiff himself was negligent and that TKE is somehow responsible.
But that's the outcome of the case. It doesn't take the issue out of the case until we try the case and find out, right?
Your Honor,
I mean, and that I think is the distinction that we make in these defense cases where the plaintiff is an employee of the insured. And I have to really wonder, because you were sort of pointing or thinking about like a Rodriguez analysis, but I'm not sure it applies in the issuance of coverage. That's all I say.
Your Honors, if I may, what I would say to that is it still requires the analysis of the contract, which says that if there are bare allegations or there is the acts arise from Wilcox's actions, that those are not covered. And that limitation and the analysis that Your Honor is engaged in was not the analysis the trial court engaged in. Thank you.
Okay, thank you. You may proceed.
Thank you, Your Honor. Good afternoon, Your Honors. May it please the court, I'm Susan Mahan from Gardner and Bloom, and we represent the respondent Wilcox. Your Honor is correct. The duty to defend is very broad. And this court in this past July, in the case of City of New York versus Travelers, dealt with an extremely similar issue with a policy that had a similar limitation on the duty, on the additional insured status. And this court said that even though the city might have independent acts of negligence for which they will be responsible, Travelers still had an obligation to defend. And that determination of when the obligation to defend is made based on an analysis of the pleadings, and an analysis of the policy, an analysis of the additional insured endorsement. Whether or not, and at the time that the tender was made, which is back in September of 2016, and when the tender was denied in January 2017, it was very little fact development in the underlying action, if any at all. And the tender denial there was an evaluation of the facts that said there's no way TKE is going to be responsible for that accident. Excuse me. That's not proper analysis that should be made. Again, I would refer this court to the City of New York versus Travelers case, which is directly on point. And unless there are any other questions, I will yield the rest of my time. Thank you.
Thank you. Rebuttal?
Briefly, Your Honor. Whether or not there would be comparative negligence or not, the parties are allowed to contract about who would attend to that. And in this case, the trial court did not do the analysis. It stopped halfway through the policy provision and looked at whether it could arise from TKE's act, but didn't continue after the comma for the limitation, which was that they did not have to defend for any of the actions or the of Wilcox or its omissions or bare allegations that were being made. And I believe that that's why the duty to defend is, for the most part, broad, but it is not absolute and can be contracted around. Thank you.
Thank you. Thank you both. Natoli versus Trader Joe's.
Good afternoon. Kevin Grennan for plaintiff appellant. May it please the court. There's overwhelming evidence in admissible form in this case that Nicholas Natoli, walking into the Trader Joe's supermarket, was hit by a shopping cart at the front of a line of carts pushed by an employee of Trader Joe's. We have the sworn affidavit of an independent eyewitness who said the Trader Joe employee pushed the shopping cart at the back of the line that caused one of the carts at the front of the line to hit plaintiff with enough force to injure him.
Counsel, what about the argument that plaintiff could have moved out of the way and he did not?
The video bears out, Your Honor, that the moment he stepped in front of the cart, walking into the store, doing absolutely nothing wrong, it was less than a second between the time he walked in front of the cart and the cart hit him. There was simply no time whatsoever to react. In addition to the sworn affidavit of the independent witness, we have plaintiff's affidavit. We have the accident report of Trader Joe's, which said the employee of Trader Joe's pushed the shopping cart into the back of the line of carts in the cart corral, and the cart hit plaintiff Nicholas Natoli. And of course, the video is clear as day. Plaintiff was just walking into the store, and we see right when he gets to the front of the carts move and hits his body. The defendant in the case has submitted no evidence whatsoever, no affidavits, nothing to support the proposition that plaintiff was in any way comparatively negligent
Well, based on the
or otherwise.
Rodriguez case, excuse me, but even if he were comparatively negligent, that would be determined later, would it not?
Yes, Your Honor. It's our contention, though, that the overwhelming evidence presented by the plaintiff, the lack of evidence by the defendant, demonstrates there is no comparative negligence as a matter of law on the part of plaintiff Nicholas Natoli. The idea that this isn't foreseeable, there's case law in New York, appellate case law, demonstrating that if an employee of a supermarket pushes shopping carts into people and injures them, they're negligent. The notion that defendant's argument that it wasn't demonstrated that the defendant employee did not act reasonably, it wasn't proven that he did not act reasonably under the circumstances, just does not hold water based upon the affidavits, based upon the video demonstrating that the employee pushed the cart right into the plaintiff. And we believe that the lower court should be reversed. Thank you.
Thank you. You may proceed.
Good afternoon. May it please the court. My name is Anne Marie Esposito from Conway, Farrell, Curtin, and Kelly on behalf of the defendants, respondents, Trader Joe's, and Giovanni Aponte. This is a case where a Trader Joe's employee pushed a cart into the back of a line of carts, and one of the carts at the front of the line rolled away as the plaintiff was walking past. It is our position that the lower court properly denied the plaintiff's early motion for summary judgment prior to depositions because
what the depositions have uncovered?
Depositions have not been held.
You stated that it was premature, that discovery had not been completed, and that there may be additional information. So what would the depositions uncover?
Sure. So the plaintiff was moving to strike the culpable conduct affirmative defense, and to prove that the plaintiff was not culpable, the only thing that the plaintiff submitted was an affidavit stating he could not avoid the accident. If that were sufficient, every plaintiff in every negligent case would be submitting
Did you submit anything? Did you submit an affidavit from your employee, Giovanni, to
No,
state what occurred?
No, because the question is, what was the plaintiff's conduct? What could the plaintiff see at the time of the accident?
Well,
The
wouldn't
video-
that only go to the issue of comparative negligence?
Well, if the plaintiff is moving to strike the culpable conduct affirmative defense, that's squarely...
But the affirmative defense wasn't stricken.
It was not, correct.
It was not.
And it's
So
our...
why, isn't it, so don't they have to be considered separately, though?
The culpable conduct affirmative...
Culpable conduct, your client, the affirmative defense. Don't we look at those separately? Isn't that essentially what Rodriguez is all about?
Exactly. So the culpable...
But Rodriguez says, right, you agree, that you can leave the plaintiff's culpable conduct to later and determine liability on the defendant's conduct up front if the facts warrant it, correct?
Our argument that the summary judgment motion is premature is only with respect to the culpable conduct affirmative defense. With respect to the plaintiff's motion that...
But Rodriguez says that a plaintiff is not required to eliminate issues of fact as to his or her own culpable conduct or comparative negligence in order to be entitled to partial summary judgment.
However,
that's what Rodriguez says. So therefore, should you not have then presented something to show a lack of negligence on your part?
Well, when we're talking about the culpable conduct, we're only talking about the plaintiff's conduct. And there's case law that Jimenez versus Greyhound Lines, the First Department, it's a 2021 case, that if you're moving to strike the culpable conduct affirmative defense, you still have to show as a plaintiff that you're free from negligence. When you're talking about the defendant's...
I'm puzzled here. I don't understand what... You walk into a store, and within a few seconds, you're hit by a shopping cart that's being pushed in a line by an employee. How can that shopper be found negligent?
Well, the shopper, first of all, the shopper, we don't know what he saw at the time of the accident. The
I
carts...
don't know what he saw either, but so how can he be found negligent? He's walking into a store.
The carts...
Is there an assumption of risk here that when you walk into a store, you're going to get hit by a shopping cart?
The argument is that the plaintiff could, if you look at the video, the carts were moving before the plaintiff approached the cart corral. So did he see the carts moving beforehand? Why did he choose to cut directly between a customer?
I looked at that video. It was like a millisecond before he got hit by the carts and they were moving. You really think that video supports an argument that he was negligent?
Well, even so...
That he could have moved out of the way in that millisecond?
What are you doing? What is your employee doing pushing carts in the way of the entrance of the market where people are walking into this market?
The employee was putting the carts in the back of the corral and one of the carts at the front of the corral rolled away. So the question is, has the plaintiff ever been to this?
I don't know if rolled away is the right characterization, having looked at that
it didn't roll.
video.
Yeah.
It was pushed. It was like, we know, all wagons, they fit into each other. These were all fit into each other. Well, the one was pushed from the back, and the one on the other side, went out.
Yeah.
It's just a physical, it's a property of physics.
And you didn't even submit an affidavit from your client, from the individual Giovanni, saying that, he just kind of put the carts in the corral and one got away. Nothing.
Well, that would be to raise a material issue of fact, and our argument is that on the issue...
That would have been a what?
That would have been to raise a material issue of fact, and our argument that is on negligence, that the plaintiff failed to make a prima facie showing, because he didn't show that any of Trader Joe's conduct was not reasonable under the circumstances, or that an injury was foreseeable. The only thing that the plaintiff showed...
You don't think an injury... All right, you're out of time. I'm going to withdraw my question. We'll hear rebuttal.
Thank you, Your Honors.
How old is your client, if it's in the record? I don't remember.
He's about 31 years old at the time of the accident, 33 now. Plaintiff has demonstrated freedom from negligence, demonstrated by the video, the affidavits that were submitted. The idea that this cart was moving before the plaintiff arrived at the cart is nonsense. It was a split second, less than a second, clearly shown on the video, as the court has pointed out. It didn't roll away, it was pushed and it hit him. In addition to our position, there is no material issue of fact that summary judgment should have been granted to the plaintiff. Thank you.
Thank you. Thank you both. Shedler and Cohn versus Aon. You may proceed.
Good afternoon, Your Honors. I'm Ann Seckel of Foley and Lardner, and I represent defendant appellant Aon, Albert G. Rubin Insurance Services. Appellant seeks the reversal of the IAS court's denial of appellant's motion for summary judgment to dismiss each of the claims asserted against Aon for lack of proximate cause. Aon's position on this appeal is very straightforward. At a very high level, our position is that the law is clear and the key facts are uncontested. With respect to the law, to recover from an insurance broker for the failure to procure requested insurance, which is what plaintiffs seek to do here, the broker's conduct must be the proximate cause of the harm alleged. So the broker can only be held liable for the lack of coverage if its conduct caused the insurer to deny the insurance claim. If the insurance claim is denied or is deniable for any other reason, for in addition to and unrelated to the broker's conduct, the causal chain is broken and the broker cannot be held liable. Numerous cases endorse just this principle under the circumstances that were present in this case. So if an insurance policy, regardless of the effect of the broker's conduct, would not or did not provide coverage to the insured, the broker's conduct is rendered inconsequential. And it is the existence of this independent ground for denial that breaks the causal chain. So that is exactly what the record demonstrates here and what respondents cannot contest. The insurer, in fact, denied coverage on two separate and independent grounds, one of which had absolutely nothing to do with the conduct of Aon. Therefore, regardless of Aon's conduct, in fact, you could excise Aon entirely from this transaction and the insured would not have been afforded coverage. Therefore, Aon cannot be held responsible for this lack of coverage. Some of the background facts that are also entirely uncontested here is the fact that the insurance policy at issue contained exclusions that the insured was aware of and that Aon had nothing to do with the inclusion of in the policy. These facts are wholly disputed, and the fact that Chubb, the insurer, denied coverage on two grounds is not up for debate. There is a coverage letter in the record. It's at record 1837. It confirms explicitly that even if coverage were triggered, that coverage would be denied due to the application of two exclusions to coverage. Now, respondents claim, without any support, that the merit, the validity of the insurer's application of these exclusions needs to be adjudicated in order for that denial to be an intervening and superseding cause of the harm claimed by the respondent. But here is what is completely absent from respondents showing any precedent in support of their position. To be clear, there is no case in any appellate department or any other New York court that requires the independent ground for denial of coverage to be adjudicated and found to be proper for that ground to break the causal chain. No such rule would be workable. It would restrict a broker's defense based on facts completely outside of their control. Even if appellants were required, which they are not under any case law, to prove that the commingling, these exclusions, these policy exclusions, were properly applied.
How is commingling defined in these policies?
I'm sorry, I didn't hear you, Your Honor.
How is commingling defined?
Commingling is not defined in the policy. Commingling is referenced in the insurance policy in only 2 places in these 2 exclusions. And in that situation, the commingling is given its sensible and dictionary meaning, which means to blend together. And in fact, the record is very clear on this point.
In this case, we have a husband and wife.
Correct.
Who are the parties at issue here. And the allegation is that by using their joint funds, that's commingling and that excludes coverage. Is that correct?
So it's more than just allegations. The plaintiffs in this matter.
But if I get the sense of what you're talking about.
But that is correct. The commingling exclusions were applied by Chubb, the insurer.
See, I thought commingling usually meant something like a lawyer taking his client's funds and putting them into his operating account.
Certainly a fiduciary mixing funds with his or her client is commingling, but in the dictionary definition and the sensible meaning of commingling in this situation is a blending together.
Why is
Chubb
that
intended.
sensible? So I know you say that's sensible, but
And I can
honestly,
explain.
this didn't make that much sense to me. I know that Chubb did say that, but it was the putting together of husbands and wives' funds that they were managing. So that wasn't like a sensible, I don't understand why just saying blended, you put together, that's commingling. I just don't understand that. That's a statement, not a question.
Should I respond, Your Honor?
I'm going to let you answer Judge Mazzarelli's question.
So you're telling me that using a husband and wife's funds together to pay the rent or the mortgage on the property in which the couple lives is commingling, such that the insurance policy doesn't cover it? That's commingling?
So there were 2 clients of Shedler and Cohen's, a husband and a wife. They were both independently clients. The policy that's in place is meant to prevent and to exclude from coverage situations where an accountant mingles 2 different clients' funds. And so in this situation, where the 2 clients, they happened to be married, but nevertheless, the mixing of their funds was inappropriate. And so that was the basis for the denial of coverage.
Yeah. Thank you.
Thank you.
Thank you. You can proceed, Counselor.
May it please the court, Eric Sorensen of the law firm Stewart Acapini on behalf of plaintiffs, respondents, Shedler and Cohen. What's clear from Aon's brief and Aon's argument here is that Aon's dispute is not with Shedler and Cohen. Aon's dispute is with the law, and Aon's dispute is with a stubborn thing called the facts. And I'd like to use my time to just focus on some of the central factual issues and some of the central legal issues. First, central factual issues regarding the nature of the underlying action. In denying Aon's motion, the court below properly held that, quote, Rush did not allege merely commingling. She also alleged that she received incorrect business advice and that the allocation of payment for the Santa Monica property unfairly favored her, now ex-husband, when Shedler and Cohen had a duty to both of them, unquote. In fact, the Rush complaint contains numerous allegations that have nothing whatsoever to do with commingling. In paragraph 30 of the complaint, which runs for 6 pages, there are 9 categories of alleged misconduct. Only one of those categories refers to improper commingling. The other 8 refer to things such as failure to properly advise Rush of the purchase of the Santa Monica property, misrepresenting that Rush should pay expenses related to the Malibu and Santa Monica property, failure to provide clear financial statements, failure to communicate
So if I can
important
stop you
financial.
for a minute, so really what you're claiming is that although Chubb denied coverage based on two bases, and your adversary makes the point, as long as one of them, it falls within an exclusion, the causation is broken. That would be true if each of the reasons that Chubb denied coverage were really as to the same acts. But you're saying there's commingling acts and there's other acts.
There's other acts, and Ms. Rush could have prevailed on all of her 16 causes of action without ever showing any commingling. So that's what Justice Crane properly found. There's no proximate cause there's no break in the chain of proximate causation because there's been no adjudication of the underlying facts. There's been no liability finding that there was any commingling.
But that goes to another point. If Chubb were just downright incorrect in claiming the commingling exclusion, would that be the end of the story here, as your adversary suggests, in terms of the facts that may or may not pertain to commingling?
That is the end of the story in terms of Aon's attempt to rely upon the commingling exclusion to excuse their own misconduct. In other words, that would end their proximate cause defense as it relates to their reliance upon the commingling exclusion. And I'd also like to then turn to the law on this. Ms. Eckel indicated that we've not cited any case law. We've actually cited case law from this circuit, from the appellate division. The cases in Bruckman, the first case in which this court found where a policyholder settled the underlying claim with its insurance company, it found, quote, plaintiff's settlement of their underlying claim against the insurer under circumstances in which the merits of the underlying claim for coverage were equivocal did not break the chain of proximate causation. That's exactly our case. The underlying claim for coverage, the application of the commingling exclusion is equivocal. We disputed that. We retained coverage counsel, and we ultimately obtained a settlement contribution from Chubb to the tune of $500,000 to the settlement of the underlying action, which also raises the point that Chubb's critical fact that they need to rely upon, that Chubb somehow denied the claim for coverage. They did not deny the claim for coverage. Under the Chubb policy, Chubb had two obligations, the duty to defend and the duty to indemnify. After they issued this August 18th coverage letter, they continued to defend Shedler and Cohen, and they made an indemnity contribution in partial settlement of the Rush action. So it's simply not true that Chubb outright denied coverage. The last point regarding the commingling exclusion, which your honors asked about, there are three cases we cite. TIA Kreff, JP Morgan, New York Court of Appeals, and the In re Schreiben Third Department case. All of those cases find that commingling requires that the funds be mixed with the firm's own accounts. There are no allegations in this case, in the Rush action, that any funds were mixed with Shedler and Cohen's accounts. For that reason, our cross motion for summary judgment should be granted. Thank you.
Thank you. Rebuttal?
With respect to the claim that the underlying action against the insured did not allege merely commingling, therefore there's some impropriety to asserting the commingling exclusions against the entirety of the claim against them, as we pointed out in our briefs, and it is very, very clear from the actual complaint filed against the insureds, every single claim either arose out of, related to, or was in consequence of commingling. Ms. Rush was very clear in her complaint that the misinformation, the misrepresentations, the bad advice was all in furtherance of to facilitate the commingling. So under the clear terms of the policy, the entire claim was properly denied under the commingling exclusion. The point of all of the cases that we cite in our briefs is that the mere existence of an alternative, independent, unrelated to the broker's conduct ground for denial of coverage breaks the causal chain. If Chubb is wrong, Chubb is wrong. The day after they issued their supplemental coverage letter saying we are not going to cover you by virtue of the commingling exclusions, the causal chain was broken between Aon's conduct and the lack of coverage. To be clear, the plaintiffs allege that the insured services definition was wrong because of something Aon did. Coverage was in fact triggered and then excluded based on conduct, based on circumstances unrelated to Aon's conduct. That is the key fact. The third thing I want to point out is that Bruckman absolutely does not require an adjudication of the alternative ground for coverage. In fact, there was no alternative ground for denial of coverage at issue in Bruckman. Bruckman had to do with one reason for denial of coverage and then a settlement. That is an entirely different situation. There was no independent reason cited there. I see my time is up. Thank you, Your Honors.
Thank you. Thank you both. Aimley, step up, please.
Your Honor.
Okay, Ms. Aimley, can you just state who you are for the record? Your name?
Xi Yan.
Okay, and you're the defendant respondent in this case, is that
Respondent.
right? Okay, and I just want to straighten some things out because there was some confusion at the call of the calendar. All right, you are, the appellant is not here today, so you are the only one who's going to be addressing the court. You originally asked for 15 minutes, and I said that that was too long, and you were concerned. I cut it down to 3 minutes. What I want to assure you before you begin your arguments is this. We have, and we have had for over a week now, the briefs and the record on appeal in this case. So we are fully familiar with all of the facts in this case and the arguments that are being made. So you don't have to concern yourself that you need a lot of time to bring us up to speed on the case. We know a lot about it.
Understand.
I'm going to give you 3 minutes because I think that that is enough. If for some reason my colleagues and I have questions that keep you beyond the 3 minutes, we'll allow you to answer the questions and you'll have that opportunity. Okay?
Okay.
Okay, go ahead. Your 3 minutes starts now.
Okay. So I'm the single mother of a 9-year-old. I take care of my 92 years old father and a full-time job. I had a significant financial stresses to raise a child since the separation almost 9 years ago. With separation started, the child is 5 months old. But my ex-husband is an attorney. He legally harassed me, prolonged the cases, and at contempt of court, and caused the damage to the interest of our child, and especially right now, he significantly left behind a child support arrear $65,343. Our child custody trial finished on October 12, 2018. By the law, he should pay the child support, but he refused. So Judge Laura Drager on September 6, 2019, arrested him right on the court because he's contempt of court. Since then, totally, plaintiff has appellant filed 9 motions for decreased child support, and all have been rejected. This is the second motion at the first department. In the last 8 years, judge was changed, attorneys changed, the court was changed. He legally harassed me at 3 courts at the same time and hired 2 different lawyers. I don't have money to hire any lawyers, but I speak the truth only. He has the responsibility to pay the child support, number 1. Number 2, he has a financial capacity to pay the child support. He has the overall asset more than $3 million, including saving, investment, and 2 properties in the Battery Park. He said he has a job have issue, but he has to make a real effort. As Judge Laura Drager said in August 27, 2019, the proceeding I sent to the appellate department is that he should make an effort looking for a job. Second, he should have better judgment rather than pay the attorney fees more than child support arrears. So he should find a better job. And the job issue is not his refused not paying the child support. The child support based on his earning potential, number one. Number two, based on his overall asset. It's not his job current status. He has his responsibility. He should recognize his responsibility, but he refused so. At 4 o'clock today, I should have virtual appearance with George Kelly Levy. I'm trying to catch the time, but I asked this court carefully review the proceedings from Supreme Court from Laura Drager on August 27, 2019 and December 10, 2019. That motion 34 said very clearly about how he should pay his child support. I asked the court to reinforce the Supreme Court order and punish the appellant for his contempt of court and legally harass me.
Okay, thank you. Thank you very much.
Thank you.
Ruiz versus 829 Realty. Okay, we have two respondents here, and you each have 2 minutes, so.
Thank you.
You
Good
can
afternoon,
proceed.
Your Honors. Meryl Biscone from Rifkin Radler, and I represent the respondent attorneys in this matter. It's our position that the complaint was properly dismissed as to the attorneys. First, with respect to the breach of contract claim, the appellant never opposed this portion of our motion below, and it's our position that he was precluded from raising any argument in this respect on appeal. In any event, it was meritless. The breach of contract claim was properly dismissed as duplicative of the legal malpractice claim. Turning to the legal mal claim, this was also properly dismissed. There was no allegations of negligence against my clients. Here, the only thing the attorneys did was provide information to the insurer. This information was gleaned from the underlying complaint that this accident occurred at a construction site. There was nothing improper with that communication. Also, there was no evidence of damages proximately caused by my clients. Here, the appellant failed to show any element of damages. The pleadings specifically alleged that this was a construction site accident, so nothing that my clients did or did not do affected the appellant. And that's our position why it was properly dismissed. If the bench has no other questions, we'll rely on our brief.
Okay, thank you. You can proceed.
Good afternoon, Your Honors. Melissa Brill, Cozen O'Connor for Respondent Acceptance Indemnity Insurance Company. It is also our position that the trial court correctly granted acceptance's motion to dismiss because the policy's injury to independent contractors exclusion wholly precludes coverage for the Ruiz action. The court's decision was properly based on the allegations in the complaint and the bill of particulars, and the trial court also properly dismissed the bad faith and fraud causes of action, which were wholly unsupported, and therefore this court should affirm the trial court's order. And unless there are any questions, I will rest on my briefs.
Thank you. Thank you both. Mobile Audio versus ACIM New York. You can proceed.
May it please the court, Joshua Androphy, Marson Tenenbaum, for the plaintiff's appellants. The law is clear. A plaintiff may obtain a recovery under unjust enrichment from a non-leasee who uses and occupies premises. This is the case even when the plaintiff has a lease with another entity.
notwithstanding the general rule that a written contract governing a subject matter precludes recovery in quasi-contract. This was stated expressly by this court in the case Carlisle LLC against Beekman Garage LLC, when the court said, in the landlord-tenant context, the occupant of premises is liable to the owner of the property for use and occupancy irrespective of the existence of a lease in the name of another entity, and further went on to say that we allow plaintiff to seek an award of use and occupancy against the non-leasee occupant of the premises.
But in Carlisle, wasn't there a relationship, which I don't believe you have here? In Carlisle, was there not some type of relationship between the tenants and the defendants?
There was a relationship between the co-defendants.
And the tenants, I don't remember whether it was Carlisle or the other case, the tenants actually occupied the premises, is that correct?
Correct. That was the case in both Carlisle as well as the Gateway case, that the tenants, the party with the lease actually occupied the tenants, as well as the additional defendants also occupied the premises. And here, as alleged in the amended complaint, Nissan used and occupied the premises by using it for storage. There were Nissan materials that remained at the premises.
But Nissan never directly dealt with the plaintiffs, right? There was no direct relationship between Nissan and the plaintiffs.
Nissan did not have a contract with the plaintiffs. They did not have personnel, their own personnel at the premises.
Was there any relationship whatsoever between Nissan and the plaintiffs, other than the storage, I guess, of the properties, of the premises?
The relationship was that Nissan's materials were left at the premises, and Nissan did not remove them for many months, rendering the premises unusable either by the plaintiff or by any other party who the plaintiff may have wanted to sublease the
But you
premises.
didn't have any agreement with Nissan about storing the properties for them, did you?
There was no agreement to store the properties. There was an agreement with the dealers, the parties to the lease.
Didn't the dealers have an obligation under the sublease to leave the premises broom clean?
They did.
That's an express contractual obligation, sir, correct?
They did, yes.
So therefore, under that obligation, then they would be responsible, notwithstanding that Nissan's materials may have, quote, held over, so to speak, beyond the expiration of the sublease. So because you have an express contract that clearly imputes an obligation to the dealers, how can you possibly have a quasi-contractual claim of unjust enrichment under these circumstances when the actual sublease controls the obligation?
Because just as this court held in Carlisle and the Second Department in Gateway, the non-party to the lease that is using and occupying the property is also liable in quasi-contract if it uses and occupies the premises. And so that's the argument, and that's, I think, supported by these cases, Carlisle and Gateway, that just because you have a claim under contract against one party who you have a lease with, in the landlord-tenant context, if someone else is using that property, as Nissan did here, to store these records, then you have a claim in quasi-contract against that party who is occupying the premises. Nissan also argues that Mobile could have just disposed of these records, but it was not Mobile's obligation to do so. I see the red light is on. I'll reserve the rest of my argument for rebuttal. Thank you.
Thank you.
May it please the court, Ed Salcedo, Seyfarth Shaw. I respectfully request that Caleb Schillinger of the Commonwealth of Massachusetts, admitted pro hoc vice to the court, be allowed to argue.
You may proceed. Yes, I grant the motion.
Thank you, Your Honors, although it is disarming to hear you laugh before I even start.
Well, that's because not all of us are Yankee fans. So.
I did ask Mr. Salcido if I should start with, how about those socks? But
Yeah, no, I don't think
glad
so.
that I did.
For
yes.
some of us. Not others, but go ahead.
Good afternoon, Your Honors. May it please the Court again. Caleb Schillinger on behalf of the defendant respondent, Nissan North America, Inc., or NNA, as we've abbreviated it in our brief. I do want to start with clarifying some of the answers to the questions that were asked to counsel. First, it is correct there is no relationship of any kind between the plaintiffs in this case and Nissan North America. Nissan North America's involvement comes in when the plaintiffs finally reach out to them about materials that were left behind at the premises. This is reflected in the email that is at R86 in the record, and this is 6 months after the sublease had expired. And when plaintiffs do finally reach out to NNA about those materials, NNA quickly works with the plaintiffs to arrange for their removal from the property. The other important distinction too, Your Honors, is that in both Carlisle and in Gateway, just as was pointed out, there was a relationship between the contractual tenant and the actual occupant of the property. In both cases, they were affiliates or alter egos of one another. But the key distinction really is that in those cases, the claim for use and occupancy was brought against the actual occupant in possession of the premises. So in both of those cases, the quasi-contract claim was asserted against the entity that was in possession of the premises and using it to operate their business.
So just having your stuff there wouldn't be sufficient?
It would.
In terms of occupation, the element of occupation.
It wouldn't, Your Honor, at least within the context of Carlisle and Gateway, because what plaintiffs is really arguing for is not simply to apply the rule in those cases, but to expand it quite significantly and to reach an entirely different category of conduct and a much broader and even more tenuously removed class of individuals from the property. So in this case, NNA is simply a third party that is alleged to have supplied certain materials to the dealers who were both the contractual tenants and the actual occupants of the property, which is very different than the fact pattern.
Once they contacted your client acknowledged that the property was theirs, and how long did it take them to remove it?
I'm sorry, Your Honor.
How long did it take them to remove it once they were notified that their property was at the premises?
So the email, all that's in the record is the emails that are at R86, and the plaintiffs reached out to Nissan, I believe, on December 5th of 2018. Nissan responded in less than 2 weeks, and then I don't have the date directly in front of me, Your Honor, but soon thereafter they arranged for those particular materials to be removed. And I think that email is significant too, because if you look at it, plaintiff's owner and president doesn't say, is it all right if we get rid of this, or if we remove it, do we have your permission to do so? Instead, he says, before I dispose, if you want it. So clearly plaintiffs were signaling they thought that they had the right to dispose of these materials or to remove them. And for whatever reason, they chose to wait at least 6 months to contact Nissan or to attempt to remove them. And so to the extent that anything was left at the premises as quote-unquote storage, it was a result of plaintiffs' own actions. And they can't argue that NNA was somehow unjustly enriched at their expense or that they were prohibited from using the property as a result. As to the tortious interference with contract claim, would simply argue that it's undisputed or it's clear from the allegations in their complaint that the dealers, had already breached and independently breached the sublease irrespective of any of the alleged conduct by NNA. The dealers had failed to pay rent under the sublease, and the dealers had independently left behind other non-Nissan related materials, including furnishings. So again, under the law, NNA's alleged conduct would not be a but-for cause of the breach of the sublease, and their claim for tortious interference fails.
Well, there's an allegation, isn't there, that Nissan asked the plaintiff to keep certain records for them for several months in the premises?
So the allegation is simply that NNA, quote, encouraged the dealers to leave what are characterized as the Nissan materials at the premises. And as we argue in our brief, Your Honor, it's a conclusory allegation. It's simply a legal conclusion that NNA encouraged them to leave those materials in breach of the sublease. There are no factual allegations to actually make out a claim that NNA intentionally sought to force the dealers to breach the sublease, and that NNA's conduct was the but-for cause of that breach.
Thank you.
Your Honors.
You may proceed.
Yes, may it please the court. I want to address the emails that were attached to Mobile's president's affidavit. These are dated December, the initial ones were dated December 2018. There's nothing in the record and no basis to conclude from the record that this was absolutely the first time that the plaintiff ever reached out to Nissan to address these materials. There isn't anything in the record. This was not a summary judgment motion or trial. It's an affidavit that is amplifying the pleadings and shows that Nissan was taking responsibility. There's no of these records. There's no denial in these emails of Nissan's ownership of these records, and that's what the emails demonstrate. But the argument that this is the first time and that Mobile basically sat on its rights for 6 months is not supported by the record. It's a motion to dismiss, so it's not surprising that there is not a more expansive record as to every single effort, every single discussion about these records that were taking up the space in Mobile's premises. Just to briefly address the tortious interference claim, the encouragement by Nissan to the dealers to leave these materials in the premises, it caused a separate violation of the contract apart from the failure of the dealers to make the rent payments. And that's, and the allegations here are specific enough. We allege that they, in fact, encouraged the dealers to leave these materials, whether it's the dealers or Nissan's, in the premises and violating their contract. Thank you.
Thank you. Thank you both. SPG Advance versus KeyBank. You can proceed, Counselor.
Good afternoon, Your Honors. My name is David Austin, if it pleases the court, on behalf of SPG Advance. What I'd like to do today is two goals. Number one is to answer any of the court's questions, but number two, I'd like to suggest that plaintiff's appeal is really one looking for business certainty. There's no question on the record that KeyBank was the #1 senior priority holder. There's no question that SPG Advance was #2. What I'd like to do, though, is I'd like to take you back to May 5th, when the default occurred. 15 days later, SPG Advance issues to Costco a UCC notice requesting the funds held by Costco on behalf of the American Heritage, the underlying borrower in this case. On June 16, according to SPG, this is a contested fact, Costco counsel says to an email to me, I'm talking to accounting about dispersing your check. The next day.
But no money was actually dispersed at that time.
I think it was around $360,000.
But it wasn't dispersed.
It was not dispersed.
Didn't get the money, never got the money.
We never got the money, Your Honor.
Okay. Go ahead with your timeline.
Yeah, we didn't get the money because on the 17th, KeyBank emailed Costco and said, don't give them the money, we're #1 in line. And I looked at that email and I thought, well, this is strange. They're not saying give us the money. They're saying don't give them the money. I am unaware of any New York law that says when you're #1, you could say don't give money to #2. If you look at the treatises, on the UCC, they're nationwide. Under New York, the case that's cited is Humble Oil. It's a New York civil court case. I couldn't have come up with a better name for it. Humble Oil. I refer to it as a little case that could. basically says if you're number 2 and number 1 says you don't take, you take. We also found
Counsel, is your point that because number 1 did not exercise their right to collect on whatever lien they had, that they're out of luck?
not out of luck, Your Honor, but they waived, yes. Not out of luck. They don't need luck. They had the choice. They had the option. There's no question on the record that KeyBank knew number 2 was asking for the money. So the point is what does number 2 do? On June 17, when KeyBank basically just says, you, Costco, if you give them the money, we're going to sue you. And we sit back. And June 18 comes. Nothing happens. And so finally, on June 23rd, right, almost a week later, we had no recourse. So we filed a suit. And we said, look, they're not letting us have the money. We need to get the money. Filed an order to show cause. We're not here today. SPG is not here today saying we should have prevailed on the order to show cause. Because what happened is, after we filed our lawsuit on the 23rd, on the 30th of June, then KeyBank says, okay, we're now going to declare a default. And my understanding of the lower court's ruling was, well, it's all water under the bridge now. Because now they've declared a default, so you didn't get your money, just as this court has asked. Did you get your money? No, we didn't get the money. We didn't get the money because KeyBank said, don't give them the money. But KeyBank had, in my view...
But then it was up to Costco to decide, oh, am I going to hold this to see how this shakes out, or am I going to give the money and risk potential liability here? And so they made a business decision, Costco, didn't they? I'm going to try to get closer to my mic. Costco made a business decision, regardless of whether KeyBank had issued a default or not. And I think there is some ambiguity because there was a default declared, it just wasn't sort of asserted in the courts yet, or asserted in a form. But a default was in fact declared. But leave that aside. You know, so Costco is confronted with your claim, and they're about to pay it out. Let's assume what you say is correct. And then KeyBank comes in and says, no, we get the money. And Costco goes,
Sorry, Your Honor, I'm sorry. KeyBank never said we get the money. That's my whole point. KeyBank never said we get the money. KeyBank said don't give SPG the money.
Because we have a greater claim. So Costco, being prudent businessmen or women, say, oh my God, what do we want to get in the middle of this? We're just a stakeholder here. You know, let's talk to our own counsel. So with the bottom line being that they did not pay you before KeyBank asserted its rights in the Ohio action. It declared a default by everybody's standards, right?
My point, Your Honor, the SPG's point, Your Honor, is that the day that KeyBank said don't give them the money, and they didn't ask for the money, they waived. That's our position. And
All right, I thank you.
Yeah.
Good afternoon, Your Honors. Marco Kashakar, Nolan Heller Kaufman for the respondent, KeyBank National Association. Now, contrary to appellant's position in this case, this is not a matter of first impression in New York, and it's cited under the Blue Heron case in KeyBank's respondent's brief. This is simply a case of a junior creditor attempting to circumvent the rights of a senior perfected secured creditor, KeyBank, by relying on factually disproven allegations regarding the default status of KeyBank's loan, an opposite case law, and blatantly incorrect interpretations of the Uniform Commercial Code.
Well, counsel, your adversary points to the Humble case as controlling, and what do you have to say about that?
And Your Honor, to address, quite frankly, virtually all the cases that are raised in appellant's brief, the difference, the distinguishing factor in all those cases, namely Frierson, Humble Oil, 1CW, et cetera, is that the senior lender in those cases either never acted, even in response to a junior creditor attempting to collect collateral, or they couldn't prove that their loan was in default. either at that time or at any time subsequent. And that's just simply not the case in this matter. In this matter, KeyBank's loan, and there's a memorialization of the default on KeyBank's loan. That happened on May 4th of 2020. It's called the Fourth Amendment to Credit Agreement and Reservation of Rights Letter. And specifically, in that agreement, the borrower acknowledges that it was in default under KeyBank's credit agreement and that it was entering into a forbearance period until May 31st.
Right, does it matter that there was a forbearance?
I think it matters greatly, Your Honor, because as the Judge Masley held in the court below, the act of entering into a forbearance agreement by itself was KeyBank acting on its rights. It was preventing, it was preserving its rights to its collateral and as to its borrower. And the same can be said, quite frankly, about the argument that somehow KeyBank waived its rights by saying, don't pay the junior creditor, let's sort this out. And effectively, that's what happened with Costco. And it bears noting, and it's incredibly important, that there is no money here. Counsel failed to mention the fact that Costco has paid nobody because upon reconciliation by Costco, it was actually found that the borrower owed Costco money. Costco did not owe any money. So there was no account receivable to collect in this matter. There still is no money.
Well, I know you say that, but we don't really know that, certainly vis-a-vis the appellant in this case, though.
Well, that happened subsequent to the case being decided.
And they weren't a part of it, so I don't know how they, I don't know.
There was a settlement agreement that was entered into in another jurisdiction. And that's another aspect of this entire case, is that KeyBank did assert its rights, and there is a pending case in Ohio under which American Heritage Billiards was placed into a receivership. And quite frankly, the receivership order itself specifies that no creditors, including KeyBank, Tiger Capital, or any other creditors of American Heritage Billiards, are to take any collection action in any other jurisdiction. The court did not address that because it became moot after dismissal of the plaintiff's complaint in this case. So there is an ongoing receivership in Ohio, which quite frankly is winding down, but for Tiger Capital's action in New York, which would preclude this action from going forward, even if it was reversed on appeal. And I suppose, unless your honors have any further questions, really this is a case of first is first. There is no dispute that KeyBank is in a first position. Tiger Capital is in a second position. There is a default, and KeyBank has asserted its rights. Thank you very much.
Thank you. All right, rebuttal, please.
Thank you, Your Honors. Number one, the receivership is not relevant. The receivership wasn't formed until June 30th, weeks after SPG filed its case. So the receivership order was later. We were first in court in New York. Number two, KeyBank says they were preserving their right to collateral. I'm not aware of a New York case that says, number one, can preserve their right to collateral. Time is important here. One of the points I tried to make in the lower court was that this is a time issue. How long? This is the business certainty issue that I'm trying to point out. How long do we have to wait? How long does number two have to wait? How long can number one sit on that money? How long? A day? A week? What guidance do I give my client in collections? We're talking about a large amount of money. The amount of money that issue for SPG was on the order of $500,000. The amount of money at issue for KeyBank is on the order of like 9 or 11 million. Of course, they're a billion-dollar organization, and my client's only a multi-million-dollar organization. So the numbers don't exactly add up, but business certainty is the key here. What is New York's position on this? Humble Oil says one thing. KeyBank did the opposite. As the court pointed out, Costco didn't give us the money because KeyBank said, we're going to sue you. What right is that for number two? What does number two do? They have no recourse. There is no law that I'm aware of in New York that says number one can preserve their right to collateral. I'm not aware of it. Counsel hasn't brought it to my attention. Sorry, I don't mean to get so emotional. It's a time issue. It's a time issue. My background is patent law, intellectual property. You miss a day at the USPTO, you're done. Business certainty. Thank you, Your Honors. Thank you. It's been an honor.
Thank you. Thank you both. Caro versus Zog Sports.
Missed one, Butler. I'm sorry.
No, Butler's submitted.
Yes, a minute.
You may proceed.
Thank you, Your Honor. Good afternoon. May it please the court, Howard Richmond for the plaintiff appellant. This case really boils down to a determination as to whether or not a sports promoter can hide behind the doctrine of primary assumption of the risk when there are, in fact, safety issues that are raised. The controlling cases come out of the Court of Appeals, and it's Morgan versus State, and Morgan had within it 4 cases, and one of which is the Siegel case. And the controlling language is that comes out of the Morgan-Siegel cases are that participants will not be deemed to have assumed the risks of reckless or intentional conduct or concealed or unreasonably increased risks.
Okay, so your client signed a waiver, right? Your client had been playing in this quote-unquote gymnasium for a number of years, but he did sign the waiver. Is that correct? He was aware of the setup of the gym, of the court, of the baskets, backboard, the walls, etc. So he knew all of this and had been engaged in playing basketball, these pickup games or whatever, for that period of time.
Well, this isn't a pickup game, Your Honor. This is a league.
This is organized. These are organized games.
And that's different. And this is a league, and the league has certain responsibilities. Yes, nobody could find the actual signed waiver. However, there is a form waiver that my client doesn't dispute. That is what was on the website. However, if you take a step back to Siegel, Siegel is 18 months of playing on a tennis court in which there is a torn net for 18 months, and which has not been repaired. Everybody playing knew about it, yet the Court of Appeal said that safety still trumps the doctrine of primary assumption of the risk.
Counsel, was there a specific industry standard that your expert relied upon in order to come to
Yes.
this conclusion? What was it?
He analyzed the fact that you are dealing with, not with children, but you're dealing with adults, and looked at the high school basketball requirements for safety purposes, which were amended from 10 feet down. I'm sorry, they were amended years ago from 3 feet to 10 feet, and then looked at what the industry standard was to take care of that gap, and to take care of that gap was this removable padding. And what's more of concern is the fact that Zog, the respondent, the defendant, had locations where there was in fact padding, and you have a disparate safety standard between.
Counsel, you're like complaining on a lot of different issues. The industry standard that you're referring to, did your expert demonstrate how that industry standard, if there was one, how it was violated?
Yes, in his affidavit, he demonstrates the fact that that there should have been padding, removable padding, put up there by the sports promoter, and that was not done, and that the industry standard with 3 feet of distance
I
between.
thought the padding was for high schools.
I'm sorry.
I thought the padding requirement was for high schools.
No, the padding, when we talk about high schools, that's a misnomer, because you're talking about, this is a game being played in an elementary school put on by the sports promoter, and so you've got to protect these athletes as if they're high school students or way more than a high school student.
Okay, and so then you talked about the measurements. Did your expert actually go to the gymnasium and take the measurements to see whether it was 3 feet,
No.
9 feet, or 10 feet?
No, Your Honor, there was a site inspection that was done without the expert, that was done with counsel, and measurements were taken.
So looking at the photographs, and I recognize I'm not an expert, I would not be able to do the measurements. I would not be able to see whether it was 3 feet or 10 feet.
Well, except if I may answer the question.
You may answer it.
The expert, with all of the years of his sports experience, these gyms are built the same way. These gyms that were built in the late 50s, early 60s, whether they be in New York City or out west or anywhere else, were all built the same way, and they're built for an elementary school, and so they have 3 feet of distance. Later, safety standards changed to 10, and what I'm saying is the expert's analysis is the fact that when you are dealing with these older gyms, you put up this removable, and in fact, that is exactly what was done after the fact.
So, actually, I'm going to withdraw. I'm not going to ask that
I'm
question.
sorry.
Okay.
Did I miss the question? Was there a question?
No question.
Okay.
I thought I was going to ask when I changed my mind. Maybe on rebuttal.
Okay.
Okay. All right. Let's hear from your adversary.
Good afternoon. My name is David Schultz with Barry, McTiernan & Moore. We represent Zog Sports LLC, Zog Sports Holding LLC, Zog Sports Athletic Association of New York City, Inc.
So what your adversary just made reference to in terms of the high school association, their rule, does that constitute an industry standard?
It does not. What counsel was referring to in the expert was the National Federation of High Schools. First off, this is not a high school, so even if that was applicable, this isn't a high school. And according to Mr. Harlow—
But it's a high school gym.
This is not a high school gym. This is an elementary school gym.
Okay, but that standard, wasn't it also for elementary schools, or was it?
I do not believe so. I think that's why it was called administered by the National Federation of High Schools.
Okay.
But even if we want to say that it was applicable here, the rule that Mr. Harlow's referred to, Rule 1-2-1, suggests 3 feet to 10 feet from the baseline or the backboard to any wall. Even in Mr. Harlow's affidavit, where he's not basing anything on measurements or this, it's his understanding that there's 3 feet between the baseline and the back and the wall. So even by Mr. Harlow's own assumption of this National Federation of High School standard as an industry standard, his own affidavit says that the gym complied with it.
Counsel, what about the fact that Zog Sports, in some of the places where they held these tournaments, had padding on the walls, and in other places they didn't? Does that matter in this?
It doesn't. We're dealing with this gym and what open and obvious hazards were existing in this gym. And in fact, as this court said in Sejgowski versus YMCA in 2000, I'll quote, "Where the risk is open and obvious, the mere fact that a defendant could have provided safer conditions is irrelevant." And here, the condition of the wall, the distance between the baseline and the backboard and the wall was open and obvious. The lower court acknowledged this. There was no debate about that. The fact that the wall was unpadded, that was not hidden. That was not in a non-obvious hazard.
Well, open and obvious refers to the obligation to warn, the duty to warn. The landlord or the owner or the operator of the premises still has the obligation to keep them in a reasonably safe condition.
Well, true, but in this context, for primary assumption of the risk, open and obvious means the risk is there to be observed. It's open. It can be observed by anyone playing the basketball game, and they can make a reasoned determination as to whether they want to accept the risk of playing a game on this court. So when I'm saying open and obvious, it's not that it could have been avoided or if there's a defect in the sidewalk or in that term where it is. Here, every single risk that the plaintiff could have assumed was open and obvious, and Mr. Caro, a very experienced basketball player, even admitted he knew of the risks and played anyway. So unless there's any further questions, I would just finish by saying it's very nice to be here and talking to you while arguing an appeal from my kitchen has its charms. This is much, much nicer.
I think we like it better, too. Yeah,
I can see why.
yeah.
So thank you very much.
Thank you. Okay, rebuttal.
Yes, Your Honor, and if the court may, shortly after the decisions in Morgan Siegel, the Fourth Department considered almost this very issue in a case called Stackwick versus Young Men's Christians Association of Greater Rochester. And there they found that the YMCA there had some places with padding and some places without, and said that safety issue of treating locations differently is a question of fact for the jury, not for summary judgment.
But I thought your affidavit, I thought stated that the out of bounds area was 3 feet.
The distance between the baseline and the wall is 3 feet. That's why it requires padding.
I thought if it's under 3 feet.
It's under 3 feet.
That it doesn't require padding.
I'm sorry,
under
what?
this. The way I read the standard that you put forward, assuming that it applies, I don't know whether it does or it doesn't, but let's assume, is that if you have 3 feet distance, then no padding. Less than 3 feet, padding.
That's not how I read it, Your Honor, but it's irrelevant in the situation where you're providing padding at some locations and not at others.
Well, I don't know how that could be, though, because some places may require padding under the industry standard, and some may not.
Well,
And the other thing that I'm getting confused with, and maybe my own confusion, is you use the high school standards because it's adults playing, but it's an elementary school, so it was built to specifications for little children, and I guess they need less.
They need less stopping distance.
Safety than.
No, less stopping distance.
Less stopping distance.
Less stopping distance.
They don't, right. They don't run that fast? Okay.
They're not that big, they don't run as fast.
Okay.
In response to my inquiry about open and obvious, counsel made a distinction between primary assumption of risk and primary and non-primary assumption of risk.
I'm sorry, you got muffled a little.
I said in response to my question about open and obvious, counsel made a distinction between the primary situation and the non-primary situation, and that this is a primary situation, and therefore it was entirely up to your client, not merely just a duty to warn, but he assumed the entire risk.
My client, you could make arguments about comparative fault, but not that he assumed the risk of normal play, getting fouled. I'm not arguing here that the foul was the issue. We're arguing the safety on the walls, or the padding on the walls, the safety is the issue. So it's not open and obvious to him that Zog has another gym down the street that they're playing league basketball in, paying the same fee he paid for. It's not open and obvious to him that they've got a padding, and he doesn't.
Okay. Thank you. Thank you both.
Thank you, Your Honor.
The next case is Roberts against Maxis. We only have the appellant on that case.
Good afternoon.
Good afternoon.
My name is Harvey Greenberg. I'm the attorney for the appellant. As you see in my brief, this is a sad situation where this judge has been reversed twice on almost similar facts to this case. If you look at page 11 of my brief, she was reversed twice for finding that in appointing an independent guardian, the court made no clear findings that the petitioner was unfit for the role, and regardless, he should have been provided with an opportunity to rebut these allegations. At this so-called hearing, there was no evidence taken. There was nothing done. There was nothing under oath. There was no...
It was just colloquy.
My client couldn't even get in because of the teams. He was outside trying to get into the hearing, and he couldn't even get into the hearing. It was held without him. But even so, nobody testified. Nobody gave any evidence. And to get to the point, my client did everything that he possibly could for his father for 5 years. He sought court approval. He got approval from the court examiner. He got approval from the judge's law secretary. There is no evidence that he tried to take any money from his father. All he did is he lent money to his father. This man I've been doing guardianships for all of my legal life. This man was a perfect guardian. He did make some mistakes. I'm not going to deny that, but they were correctable. They were doable. He should have had counsel. He has counsel now, and there's no reason for him to be removed and a stranger put in after he spent 5 years of his life taking care of his father physically and financially.
I have a question. Can you explain to me why the court examiner's report covered a period of 4 years so that the errors or the claimed errors weren't brought to your client's attention for 4 years?
I'm sorry, Judge.
The court examiner's report covered a period of 4 years, right?
Right.
Can you explain to me why so many years went by before there was a report pointing out to your client that there may be errors in some of the things that he did? Why did it take so long?
He got permission to do everything that he did.
That's a different issue. But the matters that are in dispute weren't brought to his attention for many years.
He should not have, there's nothing that he did that should remove him, though.
I'm not saying one way or the other. I'm just trying to understand what happened. I'm going to withdraw my question. I'll look back at the record, Mr. Greenberg. Yeah. People versus Woodburn, step up, please. You can proceed, Counselor.
Good afternoon, Your Honors. Hina Gojima of Strickland-Levan, appearing pro bono for appellant Ms. Whitney Woodburn. I understand this has been a very long afternoon, and I would try to be as brief as possible. I really appreciate the court's time. I respectfully request that the court reduce Ms. Woodburn's sentence, which was the legal maximum 5-year term of probation, to 4 years. Given the circumstances of this case, including the clear lack of prior criminal history and the fact that she has successfully already completed 3 years and close to 11 months of probation, the legal maximum is both unnecessary and unjust in this case. First,
don't we look at it when we're trying to figure out if the sentencing is excessive? Wouldn't we look to what the trial judge was looking to at the time of sentencing rather than her post-sentencing conduct?
Yes, Your Honor, that is correct, and I will stick to the facts in the record. However, I do think that, if I may, I do think that the fact that she has already completed this time operation up to 3 years and 11 months to date successfully does reflect the fact that it was clear that her lack of low risk of a reoffense, it's something that should have been clear and was clear from the day of the incident, and it makes it even more clear today.
And that's why she got probation as opposed to the 2 1/3 to 7 that she could have potentially faced, right?
Yes, Your Honor. However, once the parties agreed that probation was appropriate and that incarceration was not necessary, the court still had a choice of and a decision to make as to what term of probation is necessary, and the legislature has specifically amended the penal code to provide for that option, and that option was
The court
not.
made that decision. Is she, I believe at the time of sentencing or before the plea, the defendant asked for 4 years probation as opposed to 5 years probation. And the court considered it and imposed the 5 years probation. Is that correct?
I'm not sure, Your Honor. I don't think that is in the record that I reviewed.
But the court anyhow imposed the 5 years probation. Is that correct?
The court imposed 5 years,
And the
yes.
defendant knew that if she pled guilty, she would receive 5 years probation. Right? She bargained for the 5 years probation as opposed to
Yes,
permanent
yes, she did plead to 5 years, Your Honor. However, that does not reduce and that does not require this court to, this court should not uphold a sentence that is in itself excessive if currently, with a fresh review, the court finds that it was excessive.
Well, how does the waiver of appeal figure into this?
Yes, I respectfully submit that.
If she validly waived her right to appeal, then why should we look beyond that?
I respectfully disagree, Your Honors. I submit that the waiver of appeal, both the oral waiver and the written waivers, were unenforceable. First, as to the oral waiver, the trial court clearly misrepresented the nature and the scope of the waiver when he stated, quote, "This means that these proceedings become final. They will not be reviewed by a higher court, the Appellate Division of the Supreme Court First Department, and/or the Court of Appeals in Albany."
But there's more. There was more. And
Yes,
then
Your
the
Honor.
court went on to articulate the exceptions.
Yes, Your Honor. However, what is important is that the court, by going on to articulate the exceptions, the court did not retract or correct its earlier statement that these proceedings were final. To Ms. Woodburn, who is being asked for the first time in her life to waive her appeal rights, this is not clear at all. This only made it more confusing that the court first says these proceedings have just become final. They will not be reviewed by any court. And adding that these are rights that still survive.
However, you will not be waiving any constitutional speedy trial claims. You will not be waiving the legality of the sentence, your competency to stand trial, the voluntariness of this plea, nor the voluntariness of this waiver. Do you understand that?
Yes, Your Honor, that is the exact.
And then he goes on to say, the appellate rights I'm referring to are separate and apart from the hearing and trial rights that we went over a moment ago. Do you understand that?
Yes, Your Honor. However, from the perspective of someone like Ms. Woodburn, who is going through this process for the very first time and has not completed high school, the initial words, this means that the proceedings become final. That is the most clear sentence in the entire transcript. Once you hear that this...
So that's what she would be focused on, that one sentence, but the further explanation of all the rights that she would not be waiving, those things she would not be focused on, and those things she would not understand.
Even if she understood those, Your Honor, it made it confusing and contradictory that on one hand, the judge is telling you these proceedings just became final and will not be reviewed, and on the other, he's saying contradictory things. And I do not think that the record currently here is sufficient to show that Ms. Woodburn really understood the nature and consequences of her rights, Your Honor.
Okay,
I'll reserve time
thank
for
you.
rebuttal. Thank you.
You may proceed.
Good afternoon. May it please the court, counsel. My name is Shane Magnetti, and I represent the people. Your Honors, this is not a reckless driving case. This is not an aggravated DWI case. This is a first-degree reckless endangerment case where this defendant drove onto the sidewalk toward a group of at least 8 people, causing at least 3 of them to dive out of the vehicle's way to avoid being struck, and then she crashed into a tree and uprooted it. She crashed into a residential building and caused extensive damage to it. And her sentence, after putting all of those people at grave risk of death or serious physical injury, was simply 5 years of probation, when she could have faced up to 15 years on the top count. She avoided any incarceration whatsoever, and she avoided having to pay restitution for the extensive damage that she caused. Her sentence is eminently fair, and my colleague offers no circumstances that would now render it excessive. As for the waiver of right to appeal, Your Honors, unless you have any questions on that, I will rely on my papers for that argument and ask that this court affirm. Thank you.
Thank you. Rebuttal?
Just very briefly, Your Honors, the people's arguments continue to rely on and focus on the crime rather than the person. The clear guidance from the legislature, the legislative history of the penal code is to focus on the person, and that the terms of probation should reflect the criminal history, which in this case is absolutely clear.
Well, that may be one part of it, but shouldn't it also reflect the seriousness of the offense?
Yes, Your Honor, that is.
This was a pretty serious offense,
Yes,
don't
Your Honor.
you think?
Yes, Your Honor.
And she actually pled to a reduced charge, didn't she? I mean, that's some leniency in that. There was another count that she didn't plead to, but it was there. It was a possibility. So the plea seems overall to be pretty fair.
Your Honor, when we do look to the totality of the circumstances and the legislative guidance, which is to consider the lack of criminal history and the risk of reoffense, on both factors, the 5-year legal maximum.
I get that, but isn't the nature of the crime also part of this too?
Yes, it is, Your Honor.
Right, and isn't this a serious offense?
Yes, and
my colleague just described it, as it's been
Yes, Your Honor.
described.
It
You know,
is a serious
it's only by
offense.
happenstance that she didn't hurt somebody here.
It was a serious offense. However, even for this exact offense, there is a choice of 3 to 5 years of probation, and her lack of criminal history and the low risk of reoffense should be considered in that calculus.
Well, maybe it was. How do we know it wasn't?
Here we have the chance to review this again, and I submit, Your Honor, that when all of that is considered today, the court should find that.
But we have to put ourselves, this comes back to your original point, and I said we have to put ourselves back into the point where the sentencing was done, where the sentencing court had information. We can't all of a sudden look at it and say, oh, she's doing great on probation, so let's reduce it. There may be other remedies for that, but they're not at this court, right?
I understand, Your Honor. I submit that when the court reviewed when we reviewed the record, only the record that was available to the district court, we can still find that the court did not give weight to the totality of the circumstances and focused on the only almost exclusively on the crime. And for example, the fact that on the day of the incident, several hours after the incident, she voluntarily turned herself into the precinct and accepted responsibility, saying it was me.
I understand, and I have to say, I think it's lenient she didn't get any jail time for this. But, all right, we'll look at your arguments, and I want to thank you. I know you're serving pro bono.
Thank you.
Please thank your law firm as well, and I thank opposing counsel. Thank you both. Thank you for your patience and waiting until the end of the day for your argument.
Thank you for the court's patience. Thank you.